DT.14.08. So,
for that you have had a limitation for controlling the delay of certain time.
your objection is fine.
So far as my instruction is concerned, we do not receive the copies of the IA. So we could find from the
Ashish Kumar Thakur.
then it has been received.
Yes, what do you say? देख लीजिए भाई. एडजमेंट चाहिए तो 1-2 साल का.
नहीं एक दिन का दीजिएगा, मंडे का दीजिए.
मतलब आप लोग सोचते हैं कि हम फाइल पढ़ें सब कुछ करें, आपको एडजमेंट
नहीं,
चाहिए.
एक सवाल तो मेरा अभी देख लेते हैं, अगर कुछ होगा वैलिड ऑब्जेक्शन तो करेंगे, नहीं तो नहीं करेंगे, बिकॉज़ वी आर रेडी ऑन मेरिट्स.
यस अननेसेसरी पुराने केसेस को कोई मतलब नहीं है. और ड्यूरिंग द पेटेंसी कोई मरता है तो मैटर इज पेंडिंग बिफोर दिस कोर्ट. क्या आप
सवाल तो मेरा दीजिए, आप लोग देख लेते हैं, कोई वैलिड ऑब्जेक्शन नहीं होगा.
नेक्स्ट
For hearing item 2, second appeal 25 of 1996.
This is the plaintiff's second appeal against the judgment of environment. Lordship, may kindly see order number 6, Lordship. The substantive question of law has been framed by this order.
Yes.
23/1996. Art Mrs. So and so on behalf of the appellant who happened to be the plaintiff in the title suit number so and so. The suit was filed by the plaintiff for declaration of title and confirmation of possession. The initiation of the plaintiff was Jitu, who again was the son of the Buddhu Saw, and that Buddhu Saw in execution of the degree purchased the suit land in which the original title holder, that is three brothers, namely Madhusudan, Tipu Sudan and Sivanandan were there. In the execution degree, land was sold and the degree holder Buddhu Saw purchased the same and took over the possession also, which have been proved in case by exhibit 5, 6 and 7 etc. After degree holder came in possession, his two sons fought out amongst themselves in the partition suit and property had fallen in the share of the predecessor of the plaintiff, that is Jitu. But according to plaintiff, Sivnaso conclusively got his name entered in the register too, also got mutation on the basis of that his heirs and settlers from them are claiming the suit land which created to cloud over the title of the plaintiff, hence they can come up before the suit. Both the courts below had dismissed the suit, holding that none of the subsequent proceedings the Sivanandan was ever made party. As such, his share in the suit property cannot be said to be sold long back in the sale. This appeal will be heard on the following substantial question of law: whether the court below had committed error of law in holding that in subsequent suit, Sivanandan or his heirs were necessary party on the face of the fact that the predecessor of the plaintiff has purchased the suit property in the court sale and obtained the possession long back. In that event, the plaintiff title can be ignored and colorable one. One fact also, Lordship, which has not been included in this order, Lordship, the Jitu Saw Lordship,
Jitu Saw, the plaintiffs are the descendants of Jitu Saw.
Lordship, plaintiff acquired the land by virtue of registered sale deed has been executed by the Jitu Saw, Lordship, in the year 1983, Lordship. Thereafter, Jitu Saw came into exclusive possession of the suit land, Lordship.
Okay.
Lordship, may kindly see the issue framed by the learned trial court, Lordship.
What was the cause of action to file the suit?
Lordship, the Sivanandan Saw, the record of right was recorded in the name of Sivanandan Saw, Lordship. Thereafter, Lordship, Sivanandan Saw, Lordship, started selling the land to some other person, Lordship. Thereafter, Lordship, suit is necessary, Lordship.
Alright, let us
Yes.
see the trial court judgment first. You read the case of the respective parties.
Yes. Trial court issue framed by.
नहीं आप थोड़ा the case of respective parties के बिना कोई issue का कोई मतलब नहीं. You filed a suit for declaration of right title interest, confirmation of
This
possession.
is a suit for decree of declaration of right title.
That's right, got it. Para 2.
Paragraph 2 से पढ़ते हैं.
हाँ.
The case of the plaintiff is that suit lands of Khata number 1 into village Guram PS district Jumla mentioned in the schedule of the plaintiff previously belonged to Madhusudan, alias Maksudan, or Ripu Sudan and Sivanandan, who were recorded in highest record of right as landlord of village Guram and In the execution of the decree by Buddhu Sahu against the Madhusudan and others, the entire village Guram along with the land mentioned in the schedule of the plenty sold in auction was purchased by the decree holder Bandhu Sahu in the satisfaction of the decretal amount, and sale was confirmed on 18/5/1935 without any objection from any corner. After a reported sale, Tetangu Sahu, son of Buddhu Sahu, sold 8 anna share to Modru Sahu. It is further stated that Jitu Sahu, the other son of Buddhu Sahu, filed a partition suit bearing number so and so, claiming his one by half share in their village and got a final decree executed in execution case number so and so. It is stated that said lands along with other lands fell in the share of Jitu Sahu, who case in possession over the same, and rent of the same was deducted from his compensation money. It is further stated that as Jitu Sahu was the sole owner and was in exclusive possession of the suit land, so he was competent enough to transfer the same, and therefore that Jitu Sahu transferred the suit land by virtue of deed of gift dated 23/6/1983 in favor of the plaintiff, that is Balram
Just a
Sahu.
moment, please hold on.
No.
Jitu's, initially it was auction sold
Yes,
in favor of the
Buddhu Sahu.
Buddhu Sahu,
जी.
Bandhu Sahu.
नहीं गलत नाम बुद्धू साहू एक्चुअली
अच्छा, ये बुद्धू साहू.
बुद्धू साहू
And how is Jitu Sahu related to Buddhu
Jitu Sahu is the Jitu Sahu and Tetanga Sahu was the son of Buddhu Sahu lordship.
Okay. So you are claiming this property post auction.
Yes. After death of Buddhu Sahu lordship, Jitu Sahu and Tetanga Sahu lordship inherited the property. Thereafter, Jitu Sahu filed a partition suit against the Tetanga Sahu.
And the defendants are the legal heirs of Shivanand.
Defendants, the some of the defendants are the purchaser lordship. The Shivanand Sahu sold the land to some other person lordship. They are the party to his foot lordship.
Nandan sold the property.
Good party.
Who was the decree judgment debtor in the auction which when the property was sold?
Madhusudan Sahu, Shivanand Sahu. They
All three of them.
They are three are they are the recorded tenant lordship. They are the party to the suit lordship.
In the earlier suit.
Earlier foot lordship.
Okay. Please continue.
It is further alleged that Shivanand Sahu got his name entered in register too with the Halka Karamchari, got some rent receipts in his name without the knowledge of the Jitu Sahu, Tetanga Sahu, and of the plaintiff. It is said that Shivanand Sahu died 4-5 years ago from the date of the institution of the suit, and on the basis of the illegal rent receipts, defendant number 1 is claiming the suit land, and defendant number 3 is claiming some lands on the basis of the settlement deed, along with they have no right, title, and possession over the same. It is said that as the defendant number 1, 2, and 3 are the falsely claiming the suit land and are illegally threatening the plaintiff to disturb their peaceful possession, so cloud over the right
That's
and title of the plaintiff.
Written statement, para 69.
G. The defendant number 1 and 2 file joint written statement. Defendant number 5 and 6 filed jointly a written statement. Defendant number 7 also filed separate written statement. No one appeared on behalf of the defendant number 4, for which the Deputy Commissioner Gumla, defendant number so and so, and have denied the claim of the plaintiff over the suit land. In their written statement, it has been pleaded the suit of the plaintiff is maliciously designed and is not maintainable and is barred by law of limitation, waiver, equiescence, and adverse possession, and is also bad for non-joinder or misjoinder of necessary party. It is said that plaintiff has no cause of action for the suit land, and suit has grossly been undervalued, according to whom the valuation of the suit property is not less than 5,000. It is further pleaded that Srinath Singh, the late father of the defendant number 1 and 2, was the real owner and possession of the suit land during all the material time except the plot number 185, 188, and he was never made party to any execution case or partition suit, so his right were never affected by such litigation as restricted with the plaintiff. It is further stated that Shivanand Sahu's possession over the suit land as proposed that except the plot number 185, 188. After evaluation of the Zamindari, the state of Bihar acknowledged him as a occupancy rate and assessed the rate in his name. He paid the regular rate till he disposed of the same by sale in the year 1979 to Santosh Singh and to Ugan Singh. It is stated that on the basis of his sale deed, Santosh Singh and Ugan Singh got their name mutated in respect of the land sold to them. it is said that Santosh Singh has also sold some lands with Bendik Tokno and with the plaintiff number 2 Panna Lal Sahu, in which the plaintiff number Malha has figured as a witness that they have also got their name mutated. In respect of plot number 185, 188, it has been said that defendant number Punya so and so acquired the land on the basis of the race settlement through Hukumnama from the Tetanga Sahu, who is also granted rent receipt in his favor. After evaluation of the Jamindari, the state of Bihar has recognized.
The auction is denied or not denied?
Not denied.
Not denied.
Not denied.
I
It
don't
is
find
admitted case, Lord.
that there was an auction.
Yes, there is an auction.
What are the issues?
Issues, Lord. Para 9, Lord. The main issue is issue number 5 and 6, Lord. Is the deed of gift executed by Jitu Sahu in favor of the plaintiff?
The point of law has been framed on the point of non-joinder of necessary party.
Point of law.
Yes, the substantial question of law.
The subsequent question of law was framed by the Honorable Court, like whether the Signal Sahu is the party to the subsequent suit or not. Subsequent suit
No,
means
where in holding that in subsequent suits, Shivanand or his legal heir by necessary party, on the face of the fact that the predecessor of the plaintiff have purchased a suit property in court sale. So what does that mean? Whether this Shivanand Sahu and his legal heirs were necessary party in this suit?
not necessary party.
I just want to know what is the import of the substantial question of law. It is talking about this
Subsequent-
suit or the previous suit.
Subsequent suit means execution case, Lordship. According to us, Lordship, the Honorable Court of think that the execution case is the subsequent suit, Lordship, and whether the Sivananda Sahu is the party to the subsequent suit or not, Lordship. According to us, Lordship. Lordship, mechanically, issue number it will be cleared, Lordship. 5 and 6, Lordship. Para 14, Lordship, findings of the issue number 4. Sorry, 5 and 6.
Para 12.
Yes, para 14, Lordship. Page 9, Lordship.
Para 12 it starts the discussion.
Yes, I will start.
And you just read para 14. Let us see the finding.
Yes. Para 14.
Yes.
The exhibit 5, the certified copy order passed in execution case number so and so by the SDO Munshi Gundla from so and so to the so and so. In this the execution case, Buddhu Sahu is the decree holder and the Babu Madhusudan Singh in the judgment debtor. By order dated 18/5/1931, sale has been confirmed and thereafter the sale certificate has been sealed and signed. From the order dated 29/5/1936, it appears that the position of the same has been delivered under order 21 Rule 95 CPC. Exhibit 6 is the certificate of sale in question. Exhibit 7, the certificate of order for delivery to certify the purchaser of land at sale in the said execution. This order dated 11/5/1936. By this order, Tetanga Sahu has been certified to the purchaser of the land. Exhibit 8 is the certified copy order of the warrant of the bailiff to give the possession of the land. In the execution case number 8 of 1954, Jitu Sahu is the thereafter plaintiff and Tetanga Sahu is the defendant. By this order, the Jitu Sahu has been allotted the land in their share mentioned in the order. Exhibit 9 is the certified copy order of the subject passed in execution case number 8/5/1954 122 5/1954. By this order, the possession of the land has been delivered to Jitu Sahu again. Tetanga Sahu, that is Exhibit 7 is certified copy order of the Special Judge Ranchi in partition suit number 79 of 44. Jitu Sahu and plaintiff, the plaintiff versus Tetanga Sahu defendant. By this order dated 4/4/45, partition suit has been decreed ex party in favor of the Jitu Sahu, that is Exhibit 10/A. Is the certified copy of the decree of partition suit number so and so passed by the Special Judge Ranchi on 10/4/1945 in favor of the plaintiff. Jitu Sahu, minor son of the Buddhu Sahu, represented through his mother and guardian Johmet Kuwar. Exhibit 8, 9, 10 and 10A relate to Jitu Sahu and Tetanga Sahu only. Exhibit 11 is the certified copy order of the SDO passed in miscellaneous case number under section 145 of the CRPC dated 5/1/1940. From this order, it appears that Jitu Sahu was the first party and Madhusudan Singh was and other were the second party. The order has been passed in favor of the first party. Exhibit 12 is the notice issued by the CO to the G2 Sahu. Exhibit 13 the certified copy of the order of the CO passed on 10/8/57 in respect of compensation case number so and so. The order is in favor of the applicant. This case is between the G2 Sahu, Tetanga Sahu. Exhibit 4 is the certified copy order passed from 1/6/1951 to 9/11/1951 by Court of the Sub-Judge Ranchi in execution case number 4751. From the order dated 9/11/51, it is evident the judgment debtor has paid the decretator due to the decree holder and the execution case has been issued on false satisfaction. Exhibit 15 is the registered deed of the partition executed by Tetanga Sahu, son of Buddhu Sahu, and Bodhna Sahu, son of Bodro Sahu. By this deed of partition, both the parties have mutually partitioned the land. The deed of partition between the Tetanga Sahu and Rodna Sahu, so it is not binding against the defendant. Defendant number has proved 14 rent receipts marked from the exhibit B to so and so. DWP
What is the ultimate finding?
findings law.
Yes.
Page 28, lots, para 24. This is the findings lots. Page 20, internal page 28 lots.
Para 24A.
A, yes. From the evidence discussed above, have arrived at conclusion that Jitu Sahu was not in possession of the suit land, and so execution of deed by in favor of the Pannalal Sahu and Balasri, the original plaintiff also, is apparently not genuine, not legal, not binding upon the defendant. I have also arrived at conclusion that plaintiffs are not in possession of the suit land except the land mentioned in the deed bearing number so and so so and so. They have never came in possession on the basis of DW, so they did not acquire any right title on the basis of deed of deed, but it has been admitted by the defendant Santosh Sahu that Pannalal Sahu is possession of the RS plot number 570 area so and so, RS plot number, so no one has claimed the plot number 560 of land, so possession of the plaintiff over the land.
Just give me a sequence. Where is this gift coming from? You have fact में sequence बताइए. ऐसे कैसे चलेगा? The property belonged to whom initially? Give me the sequence.
Let's say lands of khata number.
The details of the property is in
Yes.
dispute.
No dispute. This is admitted law.
Suit property.
The lands of khata number 1 and 2.
Suit property.
Yes. Suit property. Lands of khata
Belong
number
to
1 and 2, situated at village Guram.
सूट प्रॉपर्टी का डिस्क्रिप्शन नहीं चाहिए ना सेकंड अपील में क्यों चाहिए आई जस्ट वांट टू नो इफ देयर इज अ डिस्प्यूट इन कनेक्शन विद सूट प्रॉपर्टी देन ओनली द डिस्क्रिप्शन इज रिक्वायर्ड द सूट प्रॉपर्टी बिलोंग टू whom initially
The suit property has belonged to initially in record of right was recorded in the name of Madhusudan Lordship, alias Maksudan, Ripu Sudan, Ripu Sudan, and Simnandan Lordship.
record of rights
In record of right.
is there any dispute on this
No, there is no. It is a admitted fact Lordship. In execution case Lordship,
just a moment then what happened there was a suit
there is a suit Lordship.
suit by whom
Suit, it has been not mentioned Lordship in the entire facts Lordship. There is only a statement of execution case Lordship.
execution case
In execution case Lordship,
execution case number
execution case number
8 of 54 8 of 54
नहीं
ये partition का है।
1935 का है।
Partition should be execution.
नहीं वो तो पार्टीशन का है इसका हमारा जो है वो 1935 का है वही एग्जीक्यूशन केस नंबर 3
Execution case number 102 of 1934. At page number, internal page 9 of the judgment. 1934. Exhibit 5 is a certified copy of the order passed in execution case number 102 of 1934 by SDO Munsif.
Thereafter, Lordship, the Buddhu Sahu Lordship inherited property, he died.
Just a second. Buddhu Sahu is a decree holder.
The education case number
एक
10
सेकंड प्लीज आपको ये फैक्ट तो बहुत इम्पोर्टेंट है ना. इज द डिग्री होल्डर बाबू मधुसूदन सिंह इज द जजमेंट डेटर. $18,535 is the sale confirmation. Possession delivered.
Lordship,
29,536 possession delivered. Exhibit 6 is a certificate of sale. Exhibit 7. Okay. So it was some dues against Madhusudan Sahu.
Yes. If you
Then-
Lord, may I complete, Lordship? 1224.
अभी तो गिफ्ट डीड में हम लोग पहुंचे ही नहीं है. जब तक आप गिफ्ट डीड में नहीं पहुंचेंगे तब तक हम लोग उस पैराग्राफ को नहीं पढ़ सकते.
ठीक.
सेल कंफर्म हो गया,
हाँ.
राइट? उसके बाद देयर वर टू सन्स.
One Jitu Sahu and Titanga Sahu.
Jitu and Titanga. There was a
There was a
partition suit.
between the Jitu Sahu and Titanga.
Partition suit number 79 of 44,
Lordship.
right?
Right.
Execution case था इसका number 8 of 54,
50.
correct?
And the suit property Lordship for the fail in the share of the Jitu Sahu Lordship.
Suit property in
Jitu Sahu.
share of Jitu. Then what happened?
Thereafter, Lordship, the Jitu Sahu Lordship in the year 1983 Lordship gifted the land to the original plaintiff Lordship by virtue of registered deed of gift Lordship. 1983.
1983. Jitu
23
gifted
6 1983.
by registered 23 6
1983.
registered gift
Registered gift.
in favor of
Original plaintiff Lordship.
plaintiff.
And may I submit the defendant case Lordship.
Okay. And then
Then thereafter Lordship the
that's right. Defendant's case बताइए.
defendant case is that Singandan Singh was possession of the land Lordship.
Who is Sikhanand Singh?
The
Is he related to Madhusudan Singh?
recorded tenants Lordship. One
Is
of the
he-
recorded tenants. One of the there are three recorded tenants: Madhusudan, Ripusudan, and Singandan Singh.
Sivnandan Singh.
Lordship.
Okay, they are claiming through Sivnandan Singh.
Yes, Singandan Singh. And record of right was prepared in the name of Singandan Singh Lordship.
Okay.
And after vesting Lordship, the rent receipt issued in the name of Singandan Singh.
Only.
Only.
But there were three persons in whose name the record of rights was running. Madhusudan, Ripusudan and Shivnandan.
Singandan Singh. But record of right Lordship is finally published. It was in name of Singandan Singh.
How is it possible? Because you say that in the record of rights there were three persons.
But it was admitted case that the record of right was published in the name of Srinandan.
Okay.
And rent receipt after vesting lordship, the rent receipt issued in the name of Srinandan. And in the year 1979 lordship, in the year 1979 lordship, the Srinandan Singh sold the land to Santu Singh and Ugan Singh by virtue of registered sale deeds.
Santu and Ugan.
Ugan. This is a case of the defendant's lordship.
Registered deed.
Registered deeds, and thereafter the Santu Singh and Ugan Singh got their name mutated in the revenue record lordship.
And this Jitu Singh and others, they did not get their name mutated in the
No,
revenue
no.
records.
No,
So there was no mutation.
there was no mutation lordship.
Now you tell us that in a case where Jitu Singh is claiming the property from Madhusudan Singh,
Yes,
Madhusudan Singh in the finally published record of rights, his name was not there.
not there.
He is not the recorded tenant,
Yes,
right? But the property was sold through court auction in the proceeding against Madhusudan Singh.
earlier lordship, in the record of right there are three. There were three persons named Madhusudan, Ripu Sudan, and Srinandan Singh.
How and under what it was? This was not finally published.
It was according. I think that it is a serious record of right lordship.
Think so.
But it has not been mentioned lordship. Neither in my plate nor the written statements lordship.
So what is the finding of the court? The record of rights was in whose name?
Srinandan Singh lordship.
And not in the name of Madhusudan Singh.
No, no.
If it was not in the name of Madhusudan Singh, how the property could have been sold in execution of the dues?
Earlier lordship, it was recorded in the name of Madhusudan, Ripu Sudan, and Srinandan Singh lordship. It is admitted fact lordship. There is no dispute lordship.
What was the total area of the land as it stood recorded? And what
I
was the
think
area
that
sold
17.5 acres of land lordship.
initially?
Initially.
17.5
5
acres. And how much land was recorded in the name of this Shivanand Singh? What is the area?
Area lordship, I have to verify lordship. I am not clear, very much clear lordship.
You see, there could be, if there are three persons,
Yes,
there could be that so far as the share of Madhusudan was concerned, that was sold in the auction. And
no,
the-
it is, the record of right were jointly, were recorded in the name of three persons lordship.
then how did it change? Yes, how did it change? Name of Madhusudan Singh stood deleted because his property was sold. Maybe that his share was sold.
So for, then okay, I have
What did the court record? Para
Yes.
24A.
yes. May I read lordship? Para 24A lordship.
केस बढ़िया नहीं होते, एक ही उपाय होता है, पता है
नहीं
क्या?
बढ़िया केस है, अभी हम क्लियर करते
बढ़िया तो नहीं लग रहा।
नहीं क्लियर हम करते
अच्छा,
हैं 24A पढ़ने पर क्लियर हो जाएगा.
बढ़िया।
From the evidence discussed above, I find I have arrived at conclusion that Jitu Shah was not in possession of the suit land, and so the execution deed of gift by him in favor of the Pannalal Sahu and Malhar Sahu is apparently not genuine, not legal, not binding upon the defendant. I have also arrived at conclusion that plaintiffs are not in possession over the suit land except the land mentioned in the deed bearing number so and so. They never even came in
ये
possession.
डीड कौन सा है?
हाँ,
ये डीड
वो हम परचेज किए थे 1981 में, इसीलिए इसको एक्सक्लूड किया गया है.
किससे परचेस की?
शिवनंदन से,
शिवनंदन से
हाँ
purchase
शिवनंदन से परचेज किए थे.
की। आगे पढ़िए।
And they are never came in possession on the basis of deed of gift, so they did not acquire any right title on the basis of deed of gift, but it has been admitted by the defendant Santu Singh that Pannalal Sahu is in possession of RS plot number 570, area 35 decimal, RS plot number 570 and 30 decimal, no one has claimed the plot number 566 of the suit land. So the possession of plaintiff over the lands mentioned in Exhibit G over the plot number 566 are hereby confirmed on the basis of matter is hereby declared that plaintiff have no right title in possession over the suit land except over the plot number said plot. Accordingly, two issues are decided in favor against the plaintiff. The issue number 4, since it is proved much prior to vesting of the Jamindari, Simrandan Singh was in possession of the suit land except the plot number 185 and 188. This plot number 188 and 185 is coming in peaceful of Samuel Chuya Uram since 1954. Thereafter, neither the Jiku Saw nor the defendants came in possession. Thus, even by remaining continuously in possession more than 12 years, right by adverse possession adverse has been acquired by Shivnandan Singh and Samuel Singh Uram under Article 65 of the Indian Limitation Act. This plaintiff Panna Lal Saw has also purchased some suit land, so now he is stopped from the challenging the same. Thus, from the said discussion, I arrived in conclusion that suit is barred by law of limitation and adverse possession, acquisition, estoppel. Only this issue is decided in favor of the. But here is finding that the defendants are the possession and perfected title by way of adverse possession. But there is no pleading in the written statement.
That is
law.
not the substantial question of law.
Ye-
यही तो.
But it is
Substantial
not
question
substantial
of
question.
law.
But the learned the trial court lot add that the defendant has been perfected title by way of adverse possession. But there is no pleading.
Let
It
us
is
see
the
the
error of
statement.
record.
Error of record. Adverse possession का finding है दोनों court का बोलते हैं error.
ये गलत है. There is
Written
no
statement
pleading.
दिखाई.
Lot
Just a
में can see
moment.
WS lot से.
Just a moment, please hold on. दिखाइए जरा. Written statement. There is a concurrent finding on adverse possession.
Yes. But I have gone through the written statement. There is no pleading of adverse possession lordship. The written statement on behalf of the defendant was 5 and 6 and 7 and 8. There is no pleading lordship.
Shivanand Singh, he claimed title. He claimed title over the property.
But there is no pleading of adverse possession.
How this issue number 4 was framed? Is there any issue on adverse possession?
There is no issue of adverse possession.
Let us see.
Yes. I also verified that. Para 10 lordship. The issue claimed by learned trial court lordship. Yes. There is a issue lordship. Issue number 4. Issue number, yes, I'm sorry. Is the suit barred by limitation, adverse possession, equations, and estoppel law? But there is no pleading.
And what about the first appellate?
Yes.
They have also given the finding on adverse
But
possession.
no points has been formulated without discussing any of the evidence of any of the parties, lordship. Lordship, may can you see? Para 7, lordship. Para 7. After hearing both the parties, after going through the evidence used by the parties, I find that learned trial court, after considering the evidence adduced by both the parties, after considering the document filed by them, tightly came to the findings that Shivna Sangh was in possession of the land much before the vesting of the Jamindari in the year 1962-63. The petition in respect of suit land, except the plot number 180 and 188, allotted in favor of the Srinandar Singh with respect to the suit land. The finding the learned trial court that suit bearing plot number is coming in possession of the defendant Junia Samuel Khadia is also well founded, because his name appears in the Hugnama, that is exhibit so and so, granted in the name given. Draft Katyana has been prepared in the name of. I said, after going through the evidence with findings of the learned Munshi Jitu Sahu is not possession of the suit accordingly, the execution of the gift by in favor of Malars is not genuine. I find that there is no merit in the appeal. Is dismissed. No points has been formulated the learned trial, the learned lower appellate court lawsuit, which is mandatory in nature lawsuit.
If we,
And para 6
just
law.
a moment, if the finding of adverse possession is set aside, what will remain?
Meaning
What will
thereby,
happen? What is the consequence?
lordship, the defendants are not possession of the land. The adverse
No,
possession.
they may be in possession of the land, they may not be in adverse possession.
Then lordship, the sale certificate is a document of title. I will show that there is a series of judgment of this honorable court is that the sale certificate is a document of title. What is the document of title of the defendant? Only record of right and rent receipt, lordship.
Yes, respondent, we will, subject to what you have to say, we will frame an issue on this. Is there any pleading on adverse possession? Show me one line from the written statement that you have perfected your title by way of adverse possession. Can the court enter into an issue of adverse possession without any foundational pleading to that effect?
That cannot be done.
That cannot be done. The law is well settled on this.
But what is the case?
So whatever, the entire finding in favor of this, क्या नाम है इनका, Yajanand,
Finding actually
Srinandar Singh.
They
the
purchased the
title
land.
of, no, whatever it is, the title of Shivnandan Singh is based on adverse possession.
Not adverse possession.
Yes, you just see.
That one word has been used, but you will also see the entire judgment. What is happening? Now, what right he has acquired? Auction sale admitted. Now, what has been auction sold? It is the Jamindari right. You will also see. Now, Jamindari right vested under Land Reforms Act in 1950. So, whatever right Budu Sahu and their sons have got, that vested in 1950 Land Reforms Act. They got compensation under the Land Reforms Act. Exhibit 13 is there. So they admit that they are the landlord of the village which they have purchased through auction. So landlord's right extinguished in 1950 Act. Now royalty right remains. Section 4A of the Bihar Land Reforms Act. It saves the right of rayat.
You see, the case is it a fact that the property was jointly recorded in the name of three persons? It is
It is a Jamindari right.
that's right,
Recorded in
whatever be the
3%.
right. You see, your status was
Yes.
identical as that of Madhusudan.
Yes, Madhusudan.
Your
Yes,
status was
Madhusudan.
identical as that of Madhusudan,
Madhusudan.
right? Madhusudan, Ripusudan and Shivanand.
No, some corpus right was given to the Simnandan over certain land. Those land, it attained the status of royalty right.
Which land, which is the corpus area? Which
That
is
is-
that land? What is the description of that property?
It is noted in the.
A person who has, just tell us one thing, that the property which was auction sold to them,
Yes.
is this the same property which they are claiming, or it is they are claiming some different property?
No, property, one is a right of Jamindar. That is to auction, if the Jamindar fails to give rent to the superior landlord, Jamindari is auctioned. And royalty right, if any tenant fails to pay the rent, then that particular khata plot is put in auction for recovery of the areas of rent.
The entry in record of right is a rayati entry.
No, nothing.
Of
You're
course.
asking me. It is their own case. Paragraph 2.
You see, your status, you say that you remained as a rayat of the property,
Yes.
right?
Yes.
Therefore, your status is the same as that of Madhusudan, because your name is appearing.
No, there are two parts. One, landlord may be the landlord of the village, but some land is given in the corpus right or right as a rayat to the
You show us that finding
yes.
that the court held that you acquired the right as a right.
Yes.
Where is that finding? Because the finding is of adverse possession.
No, that was possession. Really right, I
भाई हम ये नहीं देखें. By remaining continuously in possession for more than 12 years, right adverse possession has acquired by Shivnandan Singh and Samuel Chunia Oraon under Section 65 of the Indian Limitation Act. Should we ignore this finding?
Adverse possession word, acquiescence, etc. That adverse possession word has been used.
What? Arey bhai, it's a
Possession
legal
for-
term. How
Possession for more than 12
you want
years.
us to shut our eyes to this?
Yes.
You show me that there is a finding that you had a rayati right over the law.
Yes, yes.
Where is
I
that
think
finding?
so. First, what right they have acquired? They cannot stage their leg. They acquired the zamindari right, vested in state and under land was in
Ajay,
1950.
ek second.
Now they say that
Just
it
a
is not
moment.
year.
Is there any finding here that there is a finding? Is there any finding of adverse possession or there is no finding of adverse possession? You read this and let us know whether it is a finding of adverse possession. It is not a finding of adverse possession.
Apart from this, if
Apart from, I'll frame a substantial question of law. Otherwise, I will not be able to decide it. It is something which is so shocking. Firstly, you go through the written statement and let me know. Is there any plea of adverse possession? I have not been able to see. There is no plea of adverse possession raised by the defendant. In absence of any plea of adverse possession in the written statement, right? Can any issue be framed on adverse possession? And can any finding be recorded on adverse possession?
that cannot be done.
That cannot be done. There is a finding of adverse possession. आप जरा page 29 में आइए. I am absolutely open to what you say. Page number 29. Issue number 4, para number 25. Page number 28. Read it, please. Para 25.
Since it has been proved that much prior to the vesting of Jamindari, Shivnandan Singh was in possession of the suit lands except in plot number so and so. This plot number 188-185 is coming in possession of Samuel Chuya Oraon since 1954 and thereafter neither Jitu Sheikh Sahu nor the defendant came in possession, and thus even by remaining continuous in possession for more than 12 years, right of adverse possession has been acquired by Shivnandan Singh and Samuel Chuya so and so under Article 65 of the Indian Limitation Act. The plaintiff Pannalal Sahu has also purchased some suit lands, so now he is stopped from challenging the same. Thus, from the said discussions, I have arrived at conclusion that the suit is barred by law of limitation, adverse possession, acquiescence, and estoppel. Accordingly, this issue is decided in favor of the defendant against plaintiff.
There is a clear finding on adverse possession. Written statement दिखाइए. Sure. You just go through the written statement clearly. There are 3 written statements taken.
One for 123.
अब देख लीजिए आराम से just take. Mr. Counsel, आपके lunch. आप उसको देखिए है ना? You just tell us. In case of a registered gift, with respect to landed property, is it required under normal law? In Muslim law, of course, it is required. Hiba, etc. That there has to be handing over.
I'm still possession of the landlord.
No, I'm just telling you. Is it required under law that it should be handed over? Handing over the gift deed by itself is handing over of the property.
Land, property lots.
This is 123 of the
Transfer of property.
Here what's in the sheet, there are two legal statements. One is by 6 and 5 and 6.
5 and 6.
Paragraph 4 that the suit is barred by the principles of waiver, estoppel and acquiescence. 5 is the suit is barred by the law of adverse coercion, limitation and adverse coercion.
This has been raised by 5 and 6.
5 and 6. And also it is there in paragraph 4 of the written statement 7 and 8 that the suit is barred by the law of limitation and adverse coercion.
That's right.
There are two written statements.
In two written statements, a plea of adverse possession has been
No,
raised.
but it has been not mentioned that he came. Date of death is very important, Lordship, which has not been mentioned. There is no pleading that
From which date?
from the which date he came into possession to the knowledge of the true owner's Lordship. It has not been mentioned. This is an ornamental statement, Lordship. Date of possession has not been mentioned, Lordship. I will show the judgment of three judgment of the Honorable Supreme Court, Lordship. Date of possession has not been mentioned, Lordship.
He is a plaintiff. Now, as per Article 65 of the Limitation Act, plaintiff has to plead and prove that from what date he has been dispossessed.
I am not claiming that was possession.
He is
He claiming
recovery of possession.
he is claiming possession. He is not
No
claiming that he has been
claiming adverse
dispossessed.
No, recovery of possession.
No, he is claiming that he is in possession. He is claiming confirmation of possession. And in the alternative, if he is not found in possession, then he is claiming
Recovery of possession.
he is claiming to be in possession of the
finding
property.
that he is not in possession. So, if he is not in possession, then automatically the question will arise from what date he is been dispossessed. And if
No,
it
he is already in possession.
no, he is not in possession.
He claims that he is
And
in
he
possession.
claims that is his claim, but he has to prove that he was in possession, and if dispossessed, then recovery.
Yes.
Now, if he says that he is in possession, so declaration of possession only.
So the foundation pleading for adverse possession is the date on which you actually get the adverse possession, isn't it? Since when?
Then it is later development by decisions, because when the suit was filed, law was not so strict on adverse possession.
Very strict.
Yeah, now it is later decision. The
Yes,
suit
from the
filed-
beginning, from the
suit
beginning.
filed in 84.
So the court declared your title apart from adverse possession?
Because I am defendant, he has to do.
That's
I
right.
say that I am
You
the
see, he
citizen.
claims that he got the property by way of auction sale,
Option C.
right? That sale certificate has lot of sanctity, right? Because it's a court sale.
A court sale, that's it.
Yes. He also produced a document regarding handing over of possession, because court sale is followed by handing over possession, and this exhibit number 5, 6, 7, 8, these are all related to auction sale and handing over of the possession of the property.
Not
So at
property,
that point of time, he was certainly put in possession.
put in possession, what possession has been, what right has been given under the auction sale? It is the right of fixed intermediary.
landlord said zamindari right was auctioned. So
No,
whatever-
where is your case that it was zamindari right which was
No,
auctioned?
that is their case or itself. Rent, they have said it is zamindari right. They have, your lordship will again read para 2 of the judgment. Start the case of the plaintiff is that the lands of Khata number 1, Khata number 1 is a Jamindar's Khata, and to a village Guram, to so and so district Gumla mentioned in schedule of the plaint, previously belonged to Madhusudan alias Maksudan, Rukusudan and Sivnandan, who were recorded in RS record of right as landlords of village Guram, and in execution of a decree by Bandhu Sahu against Madhusudan and others, the entire village Guram along with the suit land mentioned in the schedule of the plaint was sold in auction and was purchased by the decree holder Buddha Sahu in satisfaction of the decretal amount, and the sale was confirmed so and so without objection and from any corner. After the aforesaid also said Tetenga Sahu or son of Buddha Sahu sold 8 Anna shares to Mudra Sahu.
Okay.
It is further said that Jitu Sahu, the other son of Buddha Sahu, filed a partisan suit bearing so and so.
Now you just come to the question of law once again. Whether the courts below have committed read it please. Ready?
Yes, question. Whether the court below had committed error of law in holding that the subsequent suit Signandar or his heirs were necessary party on the
ये
face
जो
of
subsequent suit की बात कर रही है
Subsequent-
कौन सी suit की बात कर रही है?
according to us lordship, subsequent suit means execution case lordship. According to us lordship.
According to means-
The
Which
partition to between the Jitu Sahu and Tetanga Sahu.
वो तो internal है
Internal है.
तो कौन सा सूट का बात कर रहे हैं?
हमको तो लग रहा है कि जो एग्जीक्यूशन केस है उसी को सब्सिक्वेंट सूट कोर्ट बोल रहे हैं.
Maybe in this suit.
मे बी लॉर्डशिप.
चलिए आगे बढ़िए.
होल्डिंग दैट
Suits है plural भी है.
subsequent suits Signandar or his heirs were necessary party on the face of the fact that the predecessor of the plaintiff has purchased the suit property in the court sale बोल रहे हैं, ऑक्शन के बारे में बोल रहे हैं, and obtained the possession long back. In that event, the plaintiff title can be ignored as a colorable one. ये ऑक्शन सेल के बारे में बोल रहे हैं. According to us, lordship, the execution case के बारे में बोल रहे हैं. Subsequent suit का मतलब.
The land was settled in the name of Chunia Sahu. Who is Chunia Sahu?
Who is another person? It is a-
Your predecessor?
151.
Your predecessor.
No, not predecessor. It was settling from the Jamindar.
ऑक्शन हुक्मनामा से
Purnama se बोल
उनको हुक्मनामा से
उनका प्रॉपर्टी इसमें नहीं है.
उनसे कोई मतलब नहीं. हुक्मनामा से.
यहाँ शिवनंदन साहू जो सेल किए थे उदन साहू एंड संतोष सिंह को, वो संतोष सिंह से इन लोग भी खरीदे. प्रिंटिंग नंबर 2 इन विच प्रिंटिंग नंबर 1 इज
We purchased in 1981 में and gift it executed in the year 1983 lordship.
खरीदे हैं ना, एग्जिबिट जी है.
हाँ हम तो खरीदे भूल ही रहे हैं.
हम ही से खरीदे हैं.
9081 का और गिफ्ट हुआ 9083 में, उसमें कोई दिक्कत नहीं।
गिफ्ट मतलब प्रॉपर्टी है, गिफ्ट होगा कर सकते हैं, if you have a valid right.
See, now there is a concurrent finding so far as adverse possession of this Shivanand Singh is concerned. So therefore, on the face of this concurrent finding of adverse possession in favor of Shivanand Singh, what right survives?
No, sir, but there is no pleading lordship, adverse possession lordship.
That is not the substantial question.
May frame lordship additional substantial question of law lordship.
Yes.
May be framed of the additional substantial question of law. I will show the judgment of the Honorable Supreme Court Lordship. That date is very much important, Lordship. The date is important, and the hostile position to the knowledge of the real owners, Lordship. There are 3-4 ingredients, Lordship. But there is no 3 ingredients in written statements, Lordship.
Limitation.
One thing also important, Lordship, may consider, Lordship, no points has been formulated. Order of 41, Rule 31 is mandatory. I will show the latest judgment of the Honorable Supreme Court, Lordship. And without discussing any of the evidence by the learned First Appellate Court, Lordship. No points has been formulated, which is mandatory in nature.
Which the appellate court does.
Yes. Para 6 Lordship, mechanics. Para 6. Page, internal page 6, Lordship.
Yes. They claimed that they are rayats over the property. They are the persons who had filed the M form, and the finding is that they were in possession much prior to vesting. If there is any error in the M form, and if rent receipt is issued, then under the Bihar Land Reforms Act, any person aggrieved has a remedy, isn't it? So therefore, issuance of M form and ultimate issuance of rent receipt is otherwise conclusive if you do not challenge those orders, right? So therefore, their rayati interest was acknowledged by the state, and what you purchased was the zamindari interest. Therefore, under such circumstances, there is no point.
No.
You purchased zamindari interest, the zamindari vested.
I purchased the.
Why did you file M form? At any point of time, you have not produced any rent receipt. Rightly so, because you were the zamindar. There was no occasion for you to have rent receipt prior to vesting. There was no occasion, correct?
Correct.
Yes. After vesting also, you did not file your M form, and you did not take any step as to how the property vested.
But the
And then there is a gift deed. This
But
is how it is.
I am putting a question to myself. What is the document of title of the defendants? What is the document of title of the defendants? The M form is not a document of title. The rent receipt is not a document of title. The plaintiff acquired the land in auction procedure lordship.
No. M form is a very strong evidence of the fact that they were the rayats over
But
the
it
property.
has not been mentioned in the WS lordship. It is required to be pleaded.
M form they have already furnished.
But there is no pleading.
So there is pleading. They say that they are the rayats over the property. What do you say? There is no pleading
But
over
there
that.
is no pleading.
You see, you claimed that your predecessor in interest was a zamindar. They claim that they are the rayats.
No, not zamindar. I am the auction purchaser.
Your predecessor in interest,
What
they
the
were the zamindar.
auction purchaser, lordship?
Your predecessor in interest who purchased from Madhusudan.
Yes.
Madhusudan was a zamindar. That was your specific pleading.
Yes.
So what you purchased? You purchased the
Purchase
zamindari
the
interest.
land,
No,
not
no,
the
no,
zamindari.
no,
Land
no.
purchased by land.
No.
Purchased by land.
No.
Thereafter, lordship, the Jitu Saul lordship executed the gift deed in favor of the plaintiff lordship. That gift deed was never challenged by the defendant. And the learned first appellate court lordship has not been framed any points lordship, which is mandatory in nature lordship, without the discussing any of the evidence of the parties lordship. I will show the judgment of the Honorable Supreme Court lordship, whether the order 41 rule 31 is a mandatory or nature or not lordship.
Respondent, one more thing. The appellate court have they discussed any evidence? They have discussed it here somewhere. You see, let us turn the pages. Para 2 is the case of the defendant, right? Para 3, they have recorded that what was the issue framed by the court at the end of para 2. Then argument of the counsels for the appellant. Para number 4 is argument of the counsel for the respondent, and para number 5, right?
In para 6, the submission of the appellant's loans.
And yes, para 6 is the submission of the appellant.
Para 7 is findings.
I find that
Yes.
from the evidence discussed above,
Para
in
4,
para 6 it is mentioned.
Only one jamindari and pawn loans. Other evidence
Inform is
ignored by the learned first appellate court.
inform is submitted by the landlord. He obtained compensation by
Who obtained compensation?
landlord. Exhibit 13. This document trial court will not see missing.
Exhibit 13, he obtained
He
compensation.
obtained compensation by filing inform is filed by the landlord, showing that these are the tenants from whom we are deriving this much rent. Now
So-
that basis
So
compensation is assessed.
name of your predecessor Shivanand Singh is also there in the
Inform must be informing. Otherwise,
You just tell us कौन सा form में कौन सा exhibit है?
informing
Inform is exhibit number.
Exhibit 13 is a certified copy of the order of CO passed in conference with respect of compensation case number 73 of RA 5556.
Yes, here you. Exhibit 13.
30.
Right. There was not only a direction for payment of compensation, but and the fair rent we also fixed in his name. That ad interim payment of compensation will be made to him, and the fair rent also will be fixed in his name. Form M has been exhibited.
No, that is not good.
That has not been exhibited.
This landlord's form, because it will show that all the person who has been settled here.
Yes.
So that has been suppressed.
And when was the rent fixed for you for the first time?
This is after
What is the oldest rent receipt you have?
this B series. B series.
Salary was executed in the year 1977. Thereafter, lots of rent receipt issued. Page 15, lots of on the learned trial court.
Defendant number 1 is 214 releases in March.
The
The
draft
earliest rent receipt is 2/1/1986.
That is purchases.
Nikita heard the learned counsel appearing on behalf of the parties. During the course of arguments, the learned counsel for the appellant has submitted that while framing substantial question of law by the order dated 23/1997, it has been observed by this court that any other substantial question of law may be raised at the time of hearing of the appeal. The learned counsel submits that the learned trial court has recorded a finding of adverse possession, and such finding has been confirmed by the learned first appellate court. But while confirming the finding, he has also submitted that the learned first appellate court has neither framed any point for determination and nor has appreciated the materials available on record and has not even discussed the same. The learned counsel has submitted that the foundational pleading with regard to the plea of adverse possession was never raised in the written statement. Merely a statement that the suit is barred by adverse possession is not sufficient to claim adverse possession. He has also submitted that even in the findings of the learned court, there is no specific date on which the possession became adverse. The learned counsel has also submitted that two additional substantial questions of law may be framed in this case. A, whether the judgment passed by the learned first appellate court conforms to the requirement of law under Order 41 and 31 of CPC. B, whether the learned court was justified in giving a finding of adverse possession without satisfaction of foundational pleading with respect to adverse possession. The learned counsel for the respondent has opposed the prayer. He has further submitted that by way of judicial pronouncements, there have been certain more requirements with respect to plea of adverse possession. But at the time when the suit was filed, such foundational plea, the so-called such foundational plea were not required to be raised. He has submitted that the fact that the written statement indicated that the suit was barred by adverse possession was sufficient for the learned court to record a finding of adverse possession. So far as the other substantial question of law regarding Order 41, Rule 31 is concerned, it is not in dispute that the learned first appellate court has not framed any point for determination. And many of the evidences have not been discussed. In view of the aforesaid facts and circumstances, this court is inclined to, this court is of the view that the following two substantial questions, the aforesaid two substantial questions of law do arise for consideration in this appeal, which are accordingly framed for further consideration. Dono, both of them. When do you want to do it? You just
Next week lordship immediately.
आप बताइए, नहीं रेस्पोंडेंट को ज़्यादा मेन करना पड़ेगा ऐसे नहीं.
Sir,
आप बता दीजिए सर, whatever is convenient. Please go through the records. We do not disclose our mind like that. ऐसा कुछ नहीं है, absolutely open. लेकिन थोड़ा सा तो उसमें दिक्कत है. फर्स्ट एपिलेट कोर्ट में थोड़ा सा
फर्स्ट अपील कोर्ट थोड़ा सा क्रिटिकल है.
एक चीज़ और लिखी. The learned counsel for the respondent has also submitted that in case this court finds that the requirement of Order 41, Rule 31 has not been complied with by the learned first appellate court, then under such circumstances the matter would be remanded to the first appellate court for appreciation of material, and the other substantial question of law need not be answered. उसमें तो सब हो जाएगा.
sir.
ठीक है?
तो जजमेंट लिखना पड़ेगा.
Then they will consider everything, whatever it
Yes,
is.
yes.
आप बताइए कब करते हैं इसको? बताइए.
27.
With the consent of the learned counsel for the parties, the matter is directed for further hearing on the three substantial questions of law, one framed earlier and the two framed today.
29 कर दीजिए lordship.
For
29.
29, do you have any objection?
तो फ्राइडे हो.
Friday नहीं होगा, please. आप कहीं जा रहे हैं क्या बाहर?
नहीं नहीं अदर जगह से 26 कर दिया जाए.
26
26 कर दीजिए.
On 26 for
And
further hearing at 2:15
Yes.
to be taken up as first case.
lordship. Okay.
वो जजमेंट्स लेके आएंगे. सर हमको लगता है फर्स्ट एपिलेट कोर्ट हैज रियली नॉट सीन द रिकॉर्ड्स.
जजमेंट हम दिए लॉर्डशिप 2022 का 3 एससी पेज 90 लॉर्डशिप मिर्दुला केस लॉर्डशिप.
हाँ.
पैरा 8 लॉर्डशिप में कैन यू सी माय रिटन
अभी एक तो जजमेंट आपका फाइनल किया था ना. आप क्यों बोल रहे हैं? मुकुल का कल परसों.
पैरा 8 एक बार खुद परमिशन देके तुम पढ़ा सकते हैं.
नहीं नहीं वो वी आर अवेयर ऑफ दैट, लेकिन आप जजमेंट लेके आए.
हम दिए हैं रिटन आर्गुमेंट में लगाए हुए लॉर्डशिप.
अच्छा उसमें लगाए हैं?
लगाए हुए लॉर्डशिप.
Next case. Yes.
Record.
Yes. The learned court master is directed to detail the records of this case so as to enable the learned counsel for the parties to peruse the same.
Yes. apply.
थोड़ा ध्यान से पेरिसल करेंगे, बहुत फट रहा है सब।
नहीं सॉफ्ट
सॉफ्ट कॉपी तो स्कैन होने के लिए नहीं बोल रहे हम लोग, क्योंकि स्कैन तो हो ही नहीं पाएगा ना। It is impossible to get it scanned. Somebody will be there to assist you. आराम से बैठ के करना। नहीं, supplementary करो।
From supplementary list for admission, item 4, Contempt Civil 412 of 2023.
Yes, done.
Yes, it is.
Contempt Civil 412 of 2023. हाँ?
But they have not annexed the order.
कोई बात नहीं।
खाली
कोई बात नहीं।
सिर्फ लगाया है। कैसे सिर्फ लगाया जरूर है, लेकिन
Correct.
एक्स्ट्रा कैंसिल किया कि नहीं लिखे
कोई बात नहीं, वो आप
खाली सीओ खाली तक इनका इंडिकेट
नहीं, कुछ नहीं निकल। The learned counsel for the respondent has submitted that the order passed by this court in the writ petition has been complied and correction slip has already been issued. The learned counsel for the petitioner has submitted that the order leading to issuance of correction slip has not been annexed. He submits that if he has any grievance, any further grievance, the right be reserved with the petitioner to take steps as per law. Considering the aforesaid submissions, this court finds that the order passed by this court has been substantially complied, and this court is not inclined to proceed any further. If the petitioner has any grievance in connection with the order passed in connection with mutation, it will certainly be open to the petitioner to take steps as per law. Sorry?
should not be two जवाब मांगे आप इससे हम
वो हम इतना कहानी हम नहीं
Item 5, Contempt Civil 612 of 2023.
We have complied the order, however, payment has not been made, but reference has been made to the accountant general and general notes. This is the so-called that could not be paid.
Reference has been made to accountant general.
Yes, sir.
The payment will come from accountant general.
Yes, sir. Kindly.
No, you are making a wrong statement. Leave encashment, Lordship has already hold Lordship judgment has gone up to the Supreme Court. So for the leave encashment,
पेमेंट करके आइए ना, हम लोग को ये सब कहानी नहीं पता,
Yes, sir.
चिट्ठी बना रहे हैं।
एक बार देख लीजिए।
नहीं नहीं देखना है ना, पेमेंट करके आइए। What is this? इस कागज से एक कप चाय भी मिलेगी क्या? Can you buy 1 cup of tea? We are not bothered what orders you are passing. You just make
No, it is not order. Kindly see, Lordship.
पेमेंट पेमेंट करके आइए।
both the payment, GPF and leave encashment.
आप पेमेंट करके आइए। कितना टाइम लगेगा पेमेंट करने में? नहीं बताइए क्या प्रॉब्लम क्या है पेमेंट करने में?
पेमेंट में हुजूर एक बार सिर्फ दिखाना चाह रहे थे जो है रिकॉर्ड में डॉक्यूमेंट, उसके बाद हुजूर बिना जैसा हुजूर का आदेश होगा टाइम लेके करिए।
आप पेमेंट करके आइए ना, इसमें क्या देखना है? उनको बस
स्वीकृति दी जा चुकी है, रेफर टू।
वही तो हम बोल रहे हैं, स्वीकृति आदेश से एक कप चाय भी
और
मिलती है
ये
क्या?
प्रधान महालेखाकार को दिया गया
एक स्वीकृति आदेश से मार्केट में एक कप चाय भी मिलती है क्या? Can you buy a cup of tea from the स्वीकृति आदेश of lakhs of rupees?
एक बार देख लीजिए।
आप पेमेंट करते हैं, बताइए पेमेंट करने में
पेमेंट
Since order has been affirmed up to the Supreme Court and what they are
I'm
saying,
hearing for
so
accountant general, we have filed a counter affidavit.
yes, what that
It is for the government to
Yes,
take
Lord.
decision and issue directions. Accountant
एक बार
general
जो लिखा है ना 11 8
Custodian.
सुन रहे हैं ना आप उनकी बात?
11
अकाउंटेंट जनरल इज ओनली द कस्टोडियन। आप बोलेंगे इतना पेमेंट कर दीजिए, वो
ये
पेमेंट
हुकुम करें ना, हमको आदेश दें कि किसको कितना रुपया देना है। I'm holding their money.
बस ये एक बार देख लीजिए।
क्या देखें हम?
लेक्चर पेज 18 देख लीजिए।
क्या देखें बताइए?
नहीं फाइल नहीं हुआ है, रेडी हुआ है।
focus भी नहीं दी है।
तो बोलिए
भाई हमारे पास उसकी कॉपी नहीं है, तो कॉपी
नहीं
दे
दी,
दो।
नहीं फाइल नहीं की है।
अरे सर एक कॉपी दे दें, गुजारिश करते हैं कॉपी दे दिए, पढ़ने का हमको क्या दिक्कत?
Does it say about the GPF also?
इसी 250 रुपीस की स्वीकृति दी जाती है, 240 डेज की,
हाँ।
ठीक है। उसके समतुल्य नगद राशि का, तो ये तो आप ना क्वांटिफाई करेंगे कि वो क्वांटिफाई करेंगे?
इनको करना है। और
आप
GPF के
बताएंगे
बारे
ना
में
कि
कहीं
इतना
नहीं
रुपया
बोला।
दे देना है। और जीपीएफ का क्या किया?
कहीं कुछ नहीं बोला गया, हम अभी देखें।
वेयर इज जीपीएफ? कौन ऑफिसर है जो आपकी बात नहीं सुनता है?
Sir, my lord, हमने लिखा है कि Office of Accountant General Bhatt Sachin has requested the Secretary Department of Investment and PC to inform the Office of Accountant General of the BCA. Then the accountant will fine. आदेश दें किसको कितना
जीपीएफ का डायरेक्शन था क्या?
पूरा ओवरऑल दोनों में तो पैरा 8 में देखा जाए तो पैरा 8 में ऑर्डर है। इंटरेस्ट के साथ पैरा 8 में उसके बारे में रेफरेंस है और फिर लास्ट में हुजूर जी का
ये जीपीएफ की बात बताइए कहाँ?
हाँ, पैरा 8 so far the first grievance regarding the payment of its contribution of GPF is concerned. This course find a specific statement has been made by the respondent in their
That's right,
counter
ये तो दिया हुआ है,
दिया हुआ है।
ए एंड बी दोनों है। लीव एनकैशमेंट का कहानी आप कर रहे हैं, जीपीएफ का क्या किया? कौन है आपका ऑफिसर? कोई बात नहीं, उसी को बुला लेते हैं। उनको बोलिए ऑनलाइन ज्वाइन करना, आस्क हिम टू ज्वाइन ऑनलाइन।
एक बार हुजूर नेक्स्ट वीक में रख दिया है, जो भी होगा।
क्या करेंगे आप नेक्स्ट वीक तक? ऐसा आप क्या करने वाले हैं कि नेक्स्ट वीक तक दुनिया बदल जाएगी?
जहाँ तक लीव इनकैशमेंट की बात है तो जो हम मतलब जो विभाग की तरफ से जो
आप 240 डेज लिख के भेज दिए, कितना अमाउंट है ये कौन क्वांटिफाई करेगा?
that has to be done by the account
यस, अकाउंटेंट जनरल करते हैं, ये क्वांटिफाई नहीं, तो आपको क्वांटिफाई करना है।
authorization for every penny has to come from the state.
यस,
authorization
they are nobody to count it.
authorization has been done as per this letter.
उससे क्या होगा? कितना पैसा देना है? 1 rupee और 1000 और 1 lakh और 10 lakh? How much amount is to be paid? कौन है ये जो इस तरह से काम करते हैं? इनको पता नहीं है क्या? Who is OP number 2?
Secretary Department of Animal Husbandry and Fishery.
एनिमल हस्बेंड्री तो ऐसे ही बदनाम है हर चीज के लिए। क्या चल रहा है आपके डिपार्टमेंट?
हुजूर एक बार ऐसे हुजूर का डायरेक्शन है कि पेमेंट का तो समय दे दीजिए, पेमेंट भी हो जाएगा और जो जीपीएस के रिगार्डिंग जो भी है वो हम इंस्ट्रक्शन ले लेते हैं।
नहीं, ऐसा है कि उनको बोलिए ऑनलाइन ज्वाइन करने, उन्हीं से सुनेंगे कि जीपीएफ के बारे में साइलेंट क्यों है। उनको रिटायर नहीं होना है क्या लाइफ में? ही विल नेवर रिटायर। उनको भी ऐसे दौड़ाया जाएगा तो कैसा लगेगा? आप उनको कुछ फेवर कर रहे हैं क्या, या कुछ फेवर मांग रहे हैं?
हुजूर जो है हम वही बता रहे हैं।
तो वही ना, यू आर नॉट एबल टू एक्सप्लेन।
If it
Then I have only one option. I will institute a contempt proceedings. बताइए वो ऑप्शन सही है?
कुछ समय दे दिया जाए हुजूर, पूछ लेते हैं।
नहीं, उनको बोलिए ऑनलाइन ज्वाइन कर लेंगे। इंडिया में है कि इंडिया से बाहर है?
नहीं चाहूँगा, पता नहीं।
थोड़ा पता कर लीजिए, पता है सेकेंड हाफ में आइए, थोड़ा सा समझने दीजिए, ऐसे नहीं होगा। ठीक है, जीपीएफ के लिए हम लोग सब्स्टिट्यूशन पिटीशन का वेट नहीं करेंगे। ठीक, आप आइएगा सेकेंड हाफ में, क्योंकि यू हैव टू टेल देम दैट क्वांटिफिकेशन हैज टू बी डन बाय देम।
ये बहुत सीधी बात है। आई एम कस्टोडियन ऑफ देयर मनी, लेट द गवर्नमेंट डिसाइड किसको कितना देना है। हमको तो
इतना सीधी बात है, इनको समझ आता तब बात ही क्या।
हमको तो आदेश मिलना चाहिए, हम आपका पैसा रखेंगे।
और इसी पॉइंट पे टाइम लिए है स्टेट 1/8/25 को, जो हजूर ने दिया। आपको नहीं स्टेट।
चलिए, कंप्लायंस रिपोर्ट फाइल करने के लिए
फिर
सवा दो।
लॉर्डशिप में सबमिट होते हैं, लॉर्डशिप में जूनियर विल बी सेकंड हाफ में
तो
केस
250 में हुजूर इंस्ट्रक्शन लेके बताना है या ऑनलाइन?
उनको ऑनलाइन ज्वाइन करा दीजिए ना, क्योंकि आपको मेरी बात समझ नहीं आई।
हुजूर हम बात जो हुजूर बोल रहे हैं हम समझ गए।
क्या समझ गए?
कि
आप जो
GPF
बोलेंगे वही लिखाएंगे कि
मेरे-
जीपीएफ का अमाउंट जो है आप उनको पेमेंट करेंगे, एडमिसिबल अमाउंट।
नहीं हुजूर, मेरा कहना है कि इसको शॉर्ट पास ओवर करके 2:15 में सुन लिया जाए। एक बार हम पूछ लेते हैं क्या स्टेटस है।
हम नहीं जानते, लेकिन आप जो सबमिशन लिखाएंगे वो हम लिखेंगे कि आप उनसे उनके इंस्ट्रक्शन पे बोल रहे हैं।
जी
ठीक है, कि आप जीपीएफ का पेमेंट करेंगे और एंटाइटलमेंट नहीं होगा तो रिजेक्ट कर देंगे। कौन मना किया आपको रिजेक्ट करने के लिए?
2:15 में
Item 6, Contempt Civil 451 of 2025.
Yes, petitioner. क्या?
देखो जो रिकॉर्ड मांगा गया था
हाँ. रिकॉर्ड किस लिए मांगे थे इसका हम लोग?
ये जो रमेश हासदा केस में जो निर्णय हुआ था उसका ऑब्जर्वेशन है कि रीजन फिर लास्ट ऑर्डर देखा जाए।
हाँ ठीक.
लास्ट ऑर्डर
ये है क्या रीजन ऑर्डर?
एक चिट्ठी भी लगी हुई है जो रमेश हासदा के ऑर्डर के
आप जरा बताइए ना रीजन ऑर्डर कौन सा है इसमें?
फ्लैग के ऑर्डर।
अच्छा.
ये जो ऑरेंज कलर का जो साइड में
बहुत सारा फ्लैग है इसमें.
वो तीन जो है एक कलर में एक उसमें जो फ्लैग होगा जिसमें कि रमेश हासदा के डायरेक्शन के बाद जो अमेंडमेंट हुआ था डिपार्टमेंट ऑफ पर्सन के वो भी है और एक रीजन लास्ट वाला प्रोबेबली रीजन होगा।
उसको शर्त को निरस्त किया गया. ठीक है. ओके. 6/7/23 को उसको निरस्त किया गया बाय वर्च्यू ऑफ द ऑर्डर पास इन द केस ऑफ रमेश हासदा. उसके बाद
देखा जाए जो वो सिमिलर फ्लैग जो कलर का फ्लैग है लास्ट में रीजन होगा।
तो इसमें तो कोई रमेश हासदा का तो स्पेसिफिक जिक्र नहीं है इसमें सिर्फ यही लिखा है कि मान्यता प्राप्त संस्था से नहीं रहने के कारण तो ये रमेश हासदा का फॉलो कैसे?
यही है जो रिकॉर्ड जो लिखा है
तो नहीं है ना, ऑर्डर तो नहीं कंप्लाई किया है. रमेश हासदा में हम लोग क्या बोले?
कुछ वैसा नहीं आया है. फॉर द फर्स्ट टाइम जो हमारा रिजेक्शन की हुआ था दैट वाज चैलेंज बिफोर दिस ऑनरेबल कोर्ट. वो सिर्फ ग्राउंड ये था कि इनका 10th क्लास का सर्टिफिकेट जो है वो आउट ऑफ स्टेट का है एंड दैट वाज फाइनली बीन डिसमिस्ड. लेटर ऑन अभी जो ये सो कॉल में दे रहे हैं अपना स्टैंड, ये नया स्टैंड ले रहे हैं कि इनका इंस्टीट्यूशन जो है वो रिकॉग्नाइज नहीं है. सो फॉर रिकॉग्निशन पार्ट इज कंसर्न, I had also filed one rejoinder wherein it may clearly been stipulated that it was recognized by the state authority as well as the JAC. मेरा rejoinder थोड़ा सा देखना चाहिए उसमें पेज 6 and onwards हम लगाए हुए हैं.
प्रीवियस ऑर्डर में क्या था कि इट इज
प्रीवियस ऑर्डर में था कि ये आउट ऑफ झारखंड स्टेट से 10th क्लास का डिग्री है इनका. And that was satisfied.
हाँ बताइए.
इनका पहले उन्होंने क्या था उनका अपॉइंटमेंट लिया गया था कैंपस में उनको कहा गया 2 साल में आप मैट्रिक का सब जो सर्टिफिकेट है दे द पिटिशन वाज डायरेक्टेड टू सबमिट. Thereafter, she submitted the certificate, which were found not recognized by the state.
Which was found from outside the state.
Outside, and this particular Allahabad Sansthan certificate.
That is not the reason in the previous order. That is not the reason in the previous order. 10 pass certificates, मतलब state के बाहर से.
हाँ, state के बाहर से था, and that was cancelled.
ये मान्यता प्राप्त नहीं है.
जी.
This is the latest recent order. 23 में.
जो
23 का ही तो ऑर्डर है जो आप हमको दिखा रहे हैं 27
एक ऑर्डर है
24/7 उसके बाद वाला फ्रेश ऑर्डर कहाँ है? ये तो हुआ पहले का,
जी
उसके बाद
एक ऑर्डर ऊपर फाइल में सबसे ऊपर
क्या नाम है इनका?
मेरी माँ
मेरी
आई एम एट सीरियल नंबर 2. इसमें ये दे रहे हैं कि विचारोपरांत सर्वसम्मति से समिति द्वारा आवेदिका मेरी मातों का 10वीं मैट्रिक का शिक्षण प्रमाण पत्र मान्यता प्राप्त संस्था का नहीं होने के कारण दिनांक 24/6/22 को अनुकंपा समिति द्वारा मेरी मातों की नियुक्ति रद्द करने के निर्णय को बरकरार रखने का निर्णय लिया. मतलब वो जो पहले निर्णय लिए हैं दैट इज स्टिल कंटिन्यू.
उसमें भी मान्यता प्राप्त संस्था से नहीं
नहीं
है, बट यू हैड सेड कि मान्यता प्राप्त संस्था से इसलिए उन्होंने बोला था बिकॉज इट वाज फ्रॉम आउटसाइड द स्टेट एट दैट पॉइंट ऑफ टाइम.
हाँ, तो पहला वाला में जो जिस मीटिंग से मेरा कैंसिलेशन किया उसमें वही चीज आया.
वही तो देख रहे हैं,
हाँ,
उन्हें वही देख रहे हैं. मीटिंग से कैंसिलेशन 24/7/2023 के ऑर्डर से किया था ना.
एक मिनट जस्ट
एनेक्शर 5 यही तो है.
obtaining fresh certificate by meeting
ये लिखिए.
21/8
जस्ट अ मोमेंट,
11/8
जस्ट अ मोमेंट. देखिए कंटेम्प्ट के सिविल 451 of 2025. The records have been produced in original from the by the Learned Counsel for the respondent. The Learned Counsel for the respondent has submitted that the claim of the petitioner has been rejected by stating that the petitioner does not have a degree duly recognized by the state. He submits that the petitioner was having matriculation degree from Prayag Mahila Vidyapit, Allahabad, which is not a recognized institution. The Learned Counsel has also submitted that in writ petition being WPS number 6091 of 2023, which was disposed of by the order dated 23/4/2024, no counter affidavit as such was filed, but the petitioner was directed to approach the respondent number 2 along with the judgment passed in WPC number 3894 of 2021 and analogous cases, wherein it was held that a degree from outside the state of Jharkhand, wherein the requirement to obtain class 10 degree from an institution in the state of Jharkhand was held to be unreasonable. The Learned Counsel submits that even if the degree outside the state of Jharkhand is to be recognized, is to be taken into consideration by virtue of the order passed in WPC number 3894 of 2021, then also it has to be seen as to whether it is duly recognized by the state or not. He submits that the reason for rejection is that the degree is not duly recognized. Counsel for the petitioner has submitted that in the rejoinder, he has placed on record certain documents to show that the degree from Prayag Mahila Vidyapith Allahabad is a recognized degree. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances, it appears that the claim of compassionate appointment of the petitioner has not been rejected on the ground that the degree has been obtained from outside the state of Jharkhand. Rather, the reason is that, as per the respondent opposite party, the degree from Prayag Mahila Vidyapith Allahabad is not really recognized by the authorities in the state of Jharkhand. Considering this aspect of the matter, this court is not inclined to proceed any further in this proceeding. However, the right is reserved with the petitioner to take appropriate steps as may be permissible under law. The reasoned order which has been placed on record, which is dated 24/9/2024, be provided to a copy of the reasoned order be provided to the counsel for the petitioner by the learned counsel for the state for needful. अब उसको ये जो लास्ट वाला ऑर्डर है ये दे
हुजूर की भी रीड कोर्ट के ऑर्डर में वही था कि फर्स्ट कैंसिलेशन मेनली ऑन दैट वेरी ग्राउंड एंड सेकंड,
लेकिन हम लोगों ने उसके बेसिस पे डिस्पोजल किया था कि आउटसाइड द स्टेट नहीं,
आउटसाइड द स्टेट
वो तो कहानी अब खत्म हो गया, आउटसाइड द स्टेट का कहानी।
माइनस
वो वापस कर
Item 7, Contempt Suit 745 of 2025.
petitioner nobody appears on behalf of the petitioner. Yes, your work has been done. Yes, it is there from the date of initial joining 19/11/1976.
They have not made the payment.
Is there any direction to make payment?
Yes, last time the order was.
Last time का order नहीं, अब the writ का order दिखा. Yes, who is for the opposite party? Who is for the opposite party? Now the initial date of appointment has been shifted,
Yes.
but the payment has not been made. Who is for the opposite party?
They have filed supplementary show cause.
That I have seen. They have shifted the date of appointment.
Yes.
And is there any order for payment?
No. They have not given any reply on that.
The learned counsel for the petitioner is present. Nobody appears on behalf of the opposite party. A supplementary Ashokos has been placed on record. Are you there? Why have you not made the payment? There is a direction for making payment within 6 months.
The university has to make the payment.
You have remitted the amount.
Yes, we give
Where is
sufficient
the
amount.
you have remitted the amount?
The amounts that we give on regular basis to the university the petitioner has to provide, the university has to provide to the principal and
There is an affidavit to that effect that they will make this payment from that amount. For every amount, there is a head under which it is being forwarded. You tell us, you put on affidavit that whatever amount is available with the university can make payment from that. नहीं दे पाइएगा ऐसा affidavit.
we asked the specific authority that question that regarding the payment, and you said that the university has been provided on regular basis payments.
Said मतलब क्या? Why is it not on affidavit? वो बोले और आप सुने और आप यहाँ पे सुना रहे हैं. Why is it not on affidavit? Who is this person? Ask him to join online. Second half में बोलिए online join करने. उनको नहीं समझ आता, आपको नहीं समझ आता, कुछ तो करना पड़ेगा ना. What about payment?
Because we have given that pay scale of the
Pay scale से क्या होगा?
जो payments होते हैं वो तो your petition के order में भी है कि it has to be done by the university.
Have you remitted any amount to the university for this payment?
Because that amount is being remitted every year as per
आपके
the
affidavit में नहीं है ना? भाई अब जब पुराने से इनका डेट ऑफ अपॉइंटमेंट शिफ्ट होगा तो उसके लिए तो एडिशनल एलोकेशन करना पड़ेगा ना.
वो requisition जो है वो हमें यूनिवर्सिटी ही देगी, तो उसके बाद ही हम लोग कुछ कर सकते हैं. हमने अपने एंड से पे स्केल वगैरह सारा कुछ भेज दिया है. अब यूनिवर्सिटी
If the university calculates the amount and give you the requisition, you will pay.
yes when we have
That is
given
the
the
counsel
pay,
for the university.
when we have given the pay scale then we will.
इसमें प्रॉब्लम होगी, ये बिहार के टाइम का है, ये ऐसे नहीं हो पाएगा जब तक ये स्पेसिफिक डायरेक्शन नहीं देंगे.
नहीं, ऐसा है कि यूनिवर्सिटी अपना रिक्विजिशन भेजे कि कैलकुलेट करके इतना अमाउंट है. व्हेन इट कम्स टू देम फिर ये लोग अपना डिस्प्यूट करेंगे किसका लायबिलिटी है, लेकिन वो क्वांटिफाई तो होने दीजिए.
जी
ठीक है.
जी.
Counsel for the parties are present. The learned counsel for the opposite party state has submitted that the initial date of appointment of the petitioner has been shifted to 19/11/1976 as per the order dated 8/8/2025 annexed along with the show cause dated 12/8/1990, so 12/8/2025. He submits that if requisition comes from the university, then under such circumstances, the amount will stand quantified and the amount will be released by the state. Nobody appears on behalf of the university.
यूनिवर्सिटी इज नॉट पार्टी.
Not party.
कंटेम्प्ट केस में नहीं है, वैसे ओरिजिनल रिट में.
At this, the learned counsel for the petitioner prays for and is allowed to make the opposite party number 6 हो जाएगा registrar.
जी.
To make the registrar Sidhu Kanu University, POPS Dumka District Dumka, उनका नाम लेके कर लेंगे, है ना, प्रेजेंट इनकम्बेंट एज, खाली उन्हीं को बना दीजिए, क्या जरूरत है, एज ऑपोजिट पार्टी नंबर 3. कौन है? मिस्टर मेहता अपीयर करते हैं. हु अपीयर्स फॉर सिद्धू कानू यूनिवर्सिटी? It has been submitted by the counsel for the state that Dr. A.K. Singh normally appears for Sidhu Kanu University. The counsel for the petitioner is directed to serve the entire records of this case in 2 copies to Mr. A.K. Singh. Office is directed to print the name of Mr. A.K. Singh from the side of the opposite parties. In this case, the newly added opposite party is directed to file an affidavit as to what steps have been taken to comply the order passed by this court in letter and spirit. The fact remains that the university has to quantify the amount and send the requisition to the state for release of fund to comply the order of this court. Let a copy of this order be also forwarded to the state in a soft copy. Hold this case on 13th October. The required affidavit of the university be filed by 6th of October.
Ultimate contentious 784 of 2025.
In terms of order dated 1st of August 2025, the report was called from the Judicial Commissioner Ranchi.
It has not reached.
That is the thing not which I submitted earlier. They are playing with the court, playing with the land loser, whose land has lost blood in 2017.
The report is that no record has been received in this court.
I have also obtained the certified copy of the information slip and how the district land acquisition officer is playing.
Yes.
In 2017, land was acquired.
Report is that no such record has been received from the district land acquisition officer Ranchi through letter number 1347 within bracket Roman 2 dated 23/9/2024.
Annexure B to their counter. There is a false affidavit shown by the district land acquisition. Judicial Commissioner office will not tell false. Lie. They are playing with the court and the petitioner. Very unfortunate. 17 में मुझे जमीन नहीं है.
Same has been the report has come that it has not
इसका इस लेटर का रिसीविंग दिखाइए. You have to show the receiving of this letter. तब मानेंगे नहीं तो we will book you for false affidavit.
इसमें रिसीविंग होता तो
इंस्ट्रक्शन फॉल्स एफिडेविट के लिए क्या इंस्ट्रक्शन? सीधा सीधी 340 का प्रोसीडिंग होगा और क्या होगा? फॉल्स एफिडेविट मींस 340.
लेटर का डेट 23/9/24.
Decision has been taken. Decision has been taken for
क्या करें आपके डिसीजन का?
For referring the matter to the civil competent court.
क्या करें आपके डिसीजन का?
And Annexure B reveals that
23/9/24. 23/9/24 आज हो गया 1 साल.
आप मिले नहीं ना उनसे, समझ नहीं आ रहा आपको?
वहाँ रिटन आर्गुमेंट वगैरह सब मिले नहीं उस सेंस.
आपको समझ आ रहा है ना कि आप ठीक से मिले नहीं क्या ये? ठीक से मिलने नहीं गए क्या? हम तो बोल ही सकते हैं क्योंकि हम लोग देख रहे हैं कि झारखंड में बिना मिले कोई काम नहीं होता है.
सीनियर सिटीजन रिटायर्ड.
लेकिन इसमें इंस्ट्रक्शन लग रहा है, इसको ट्यूजडे को रख दिया.
क्या इंस्ट्रक्शन आप देंगे?
पूछते हैं कि क्यों ये भेजे हैं कि नहीं भेजे हैं, क्या बात, कहाँ रिसीव कराया. हाँ ठीक है, हाँ कोर्ट को कहाँ रिपोर्ट सही आया होगा. लेकिन एड्रेस है न्यायायुक्त को.
पैरा 8 में लिख रहा है कि हैज रेफर्ड द इशू टू द सिविल कोर्ट.
हाँ,
एनेक्सर बी लगा दी.
रेफर्ड टू द इशू टू सिविल कोर्ट.
सिविल कोर्ट कहता है हमारे पास आए हैं 1 साल हो गया.
इसी टू क्लैरिफाई दिस पॉइंट हमको
रिकॉर्ड प्रोड्यूस करिए. गए थे ना सिविल कोर्ट देने के लिए. कोई भी ऑफिशियल डॉक्यूमेंट बिना रिसीविंग के हैंडओवर होता है क्या? रिसीविंग दिखाइए.
रिसीव तो होता नहीं.
रिसीविंग दिखाइए सिविल कोर्ट का विद प्रॉपर डेट. कहीं भी मिसप्लेस हो सकता है, वी डू नॉट नो. सिविल कोर्ट में भी मिसप्लेस हो सकता है. रिसीविंग दिखाइए. Contempt Civil 784 of 2025. A report has been received from the Office of Learned Judicial Commissioner Ranchi that no record has been received from the District Land Acquisition Officer Ranchi through letter number 1347 within bracket Roman 2 dated 23/9/2024. The show cause filed by opposite party number 2. Who is the District Land Acquisition Officer Ranchi, reveals at para 8 that the then District Land Acquisition Officer Ranchi issued letter number 1347 dated 23/9/2024 has referred the dispute to the civil court. The document annexed therewith is Annexure B. However, Annexure B does not have any receiving from the civil court. Prima facie, it appears that the records have not been sent to the district court, to the civil court,
Judicial
to the district court at Ranchi.
Under DNA.
And paragraph 8 of the show cause does not appear to be correct. However, in case the matter has actually been sent to civil court, there must be some receiving in the records of the opposite party, of the District Land Acquisition Officer. Counsel for the opposite party, and at this counsel for the opposite party prays for time to seek instructions. And at his request, the matter is directed to be posted on Tuesday to be taken up as first case at 10:30.
For hearing under order 41/11, item 9, second appeal 218 of 2020.
Lordship, on previous date, your Lordship directed me to bring the order of the admission of the second appeal number 2217 of 2020 between the same parties, same arising out of the same suit plan.
2020.
Yes.
इसमें आपका क्या substantial question of law? So why is it this is arising out of a different suit?
No, original suit same है Lordship, appeal में different हुआ है. Some part of the land का deed produce नहीं किए थे, बाद में appellate stage पे produce किए हैं Lordship. Same substantial question might be. Tag कर दिया जाए Lordship एक साथ सुनने के लिए.
The impugned order is the same.
Original appeal is two different appeal, Your Lordship. Original suit is same.
Why two different appeal will be filed?
Not by same.
Two appeal इसलिए Your Lordship कि one मेरे द्वारा अपील फाइल किया, अपोजिट के द्वारा भी एक अपील फाइल किया, डिग्री पार्टली अलाउड था. एक सम पार्ट ऑफ द लैंड का डीड प्रोड्यूस नहीं किए थे, बाद में एपलेट स्टेज पे प्रोड्यूस किए वो. इसलिए सेम.
One suit is so far I don't have the copy. However, I have appeared from KPL.
वो टाइटल सूट 51 ऑफ 1989 से अराइज करता है और ये टाइटल सूट 50 से अराइज करता है.
50/12.
क्या बोलना है आपको बताइए? सेम सूट से नहीं अराइज कर रहा है. नो, द जजमेंट्स आर आल्सो डिफरेंट. आपके ऑर्डर में लिखा हुआ टाइटल सूट नंबर 51
50/12.
and this is 50/12. That was 51/89.
नहीं Your Lordship.
नहीं मतलब आप देखिए ना,
There are one.
इसका टाइटल सूट कौन सा है?
50/2012 है दोनों. 50 of 2012 dated 19th day of January 2018.
इस ऑर्डर से तो नहीं पता चला। इसमें
दोनों
इसमें ये इसमें टाइटल सूट ऑफ 51 ऑफ 1989 का कहाँ लिखा? Where is it mentioned? About title suit number 51 of 1989.
सेकंड ये 18 में ये दिखा था।
कहाँ लिखा? And where is the discussion about that?
पेज 18 में लॉर्डशिप, पेज 18 इंटरनल पेज, सिविल अपील नंबर 46 ऑफ 18 में देखा जाएगा। यहाँ पे डिस्कशन मिडिल ऑफ द पैरा। The learned court, while deciding the title suit number 51 of 1989, has not given any finding that Susila Bawri died in 1958. Rather, it came in the deposition of Noro Bawri. यहाँ पे डिस्कशन है, इसका जजमेंट भी है मेरे पास, in exhibited. हाँ, उसका रिप्रेजेंटेशन।
आप हमको एक बात बताइए, your suit property was backed by 2 sale deeds.
Yes.
Correct? Whatever was covered by that sale deed, that has been given to you.
ओरिजिनल सुशीला सेल डीड को ट्रांसफर की, उसके बाद ये सब्सिक्वेंट परचेजर है लॉर्डशिप।
ठीक है,
तो वहीं पे
तो
मेरा
सुशीला ने 2 सेल डीड से ट्रांसफर किया, एग्जिबिट 9 एंड 9/1। करेक्ट? इसके बियॉन्ड तो आपका केस नहीं है ना। एग्जिबिट 9 एंड 9/1 that has been given to you.
नहीं, इसमें क्या है लॉर्डशिप की जो सुशीला ऑलरेडी 1956 में डेथ हो गया था, वो फाइंडिंग है ये जजमेंट में लॉर्डशिप प्रीवियस भी।
आप बात को समझ ही नहीं रहे। एप्लेट्स ये वाला जो 2 डीड है, एग्जिबिट 9 एंड 9/1, राइट? इसमें 33 डिसमिल बेचा गया। You just come to page 44 of the appellate court's order. Read it, please. Internal page will be 20. 20 का bottom पर.
Whether oral or documentary.
पढ़ी?
Whether oral or documentary appellate court, but if
नहीं, in the light of the above facts.
in the light of the above fact and the provision of law appercent, the petition filed by appellant is allowed. The sale deed 18337 dated 21/6/1974 and sale deed number 5328 dated 1/5/1975 are taken into evidence on behalf of the appellant plaintiff. Sale deed number 18337 dated 21/6/1974 is marked in Exhibit 9 and sale deed number 5328 dated 1/5/1975 is marked in Exhibit 9(1). While sale deed number 18337 dated 21/6/1974, Srimati Susila Bawri, wife of late Sambhu Bawri, has sold 33 decimal out of 1.3 acre of the land under plot number 390, Khata number 5 of village Egarkund on consideration amount of 500 to Santosh Baladasi through registered sale deed number 5328 dated 1/5/1995. Susila Bawri has sold 21 decimal of land in plot number 391 and 2 decimal land in plot number 392 under Khata number 5 of village Egarkund to Santosh Baladasi. Since both these documents are taken into evidence, so plaintiff appellant are entitled to declaration of their right, title, interest and possession over the land covered by the aforesaid 2 sale deed. On the above discussion, I find that the learned court below has rightly decided.
Heard the learned counsel appearing on behalf of the appellant. He has submitted that the learned first appellate court has decreed the suit to the in favor of the plaintiff to the extent it related to Exhibit 9 and 9/1 both dated 21/6/1974 to the extent of 33 decimal both dated 21/6/1974 executed by Shrimati Sushila Bauri.
Yes.
He submits that in the earlier suit, being title suit number 51 of 1989, it was held that Sushila Bauri had died in the year 1958.
Yes.
He submits that this aspect of the matter has not been properly considered by the court, and once there is a declaration that Sushila Bauri had expired in 1958 by a competent court or civil jurisdiction in the earlier suit, therefore, no reliance could have been placed on the aforesaid two proceedings.
Yes.
He submits that arising out of the same suit,
Yes.
two appeals were filed,
Yes.
and one appeal has been admitted in second appeal number 217 of 2020,
Yes.
and this is the other appeal.
Yes.
He submits that this appeal be heard along with essay number 217 of 2020,
Yes.
and same substantial question of law be framed
Yes.
in this appeal also. एक चीज और बताएं, जब एक बार अपील में ये सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम हो गया, then why the same substantial question of law be framed in this appeal?
क्योंकि दोनों एक ही लैंड का सूट का एक ही इशू है लॉर्डशिप की सुशीला बावरी डाइड है सारा
अगर मान लीजिए सुशीला बावरी का डेथ हम लोग होल्ड कर देते हैं 1958 में हो गया है, then under such circumstances the consequences will follow.
यस सब वाइड
इसको क्यों एडमिट करें हम इसके लिए?
साथ में एडमिट करके वो लोग सिर्फ एक ही प्लॉट ऑफ लैंड टोटल लैंड इन्वॉल्व था सेम ही सूट था कुछ पार्ट
इसमें part of property involved.
Yes.
The learned counsel has submitted that only a part of the property is involved in this case.
In the earlier second appeal,
Yes.
which was civil appeal, was filed by the respondents, which was allowed.
That's
The second civil appeal number, that was challenged by the
कोई बात नहीं सर, इसको एडमिट
civil
कर लेते हैं
appeal
ना.
number 42 by
Considering the
2018.
aforesaid submissions, this appeal is admitted on the following substantial question of law. Same question of law to be heard, the appeal be heard along with essay number 217 of 2020. Record आ गया
उसमें आ गया इसमें भी कॉल कर दिया जाएगा
इसमें
डीड
क्यों कॉल करना पड़ेगा?
जो डीड लगा है पीछे से बाद में लगा है लॉर्डशिप फर्स्ट एपिलेट कोड में वो एडिशनल एविडेंस लेड करके डीड लगा दिए वो डीड देखना जरूरी है बंगाली में वो डीड फैब्रिकेटेड है ये प्रीवियस जजमेंट में भी आया है लॉर्डशिप उस डीड के बारे में इसलिए जरूरी है
तो उस रिकॉर्ड के साथ ये रिकॉर्ड नहीं आएगा क्या?
आ जाएगा तो ठीक
आ जाएगा ना, इसमें रिकॉर्ड आ गया, देखिए तो 217 of 2020
में आ गया है
आ गया है ना, तो बस अब बहस करें. The learned counsel has also submitted that the records have already been received in second appeal number 217 of 2020.
No notice need to be issued to the
Yes.
as a
एक चीज और एपलेट कोर्ट में हुआ था, दोनों का एपलेट कोर्ट का ऑर्डर कॉमन है?
नहीं अलग एपिलेट कोर्ट का ऑर्डर अलग
Since the trial court record is one and the same in
ट्रायल
both
कोर्ट
the,
रिकॉर्ड सेम
is one and the same in both the appeals, second appeals.
यस
Therefore, in this case, only the appellate court record
यस
be called for.
यस
Okay? Let the appellate court record in civil appeal number 46 of 2018 be called for from the court of learned district judge from Dhanbad. Let this matter be tagged along with essay number 217 of 2020. Since the respondents have already appeared, no notice need be issued. 20 तारीख को है, इसी के साथ लगा दीजिए. It has been reported that
I have appeared on behalf of Sunil Kumar Ghosh, the caveat has been filed.
in this case,
Yes, second appeal to
और तो किसी को नोटिस नहीं करना है ना,
है।
तो आप किसको नोटिस करने का
दो
बात?
आदमी को क्रिएट दिए हैं, सुनील कुमार घोष, आई डोंट हैव द कॉपी, आई डो नॉट नो व्हाट इज द नंबर।
तो आप बोलते हैं नो नोटिस नीड बी।
नहीं, सुनील कुमार घोष एंड साधन घोष, they are the two respondents on whose behalf I filed a caveat.
Okay, no notice need be issued so far as respond number 1 and 2 are concerned. Let notice be issued to respond number 3, 4, 3 to 6, for which requisites under ordinary process. Ordinary process तो नहीं होगा, speed post होगा, 3.1. Requisites under speed post be filed by the appellant within a period of 2 weeks from today. Office to track speed post delivery. Post this case on 13th October. 20 तारीख को जो आपका मैटर रहेगा उसको 13th को साथ में लगा देंगे.
नोटिस का रिक्वायरमेंट हो जाएगा.
क्या चीज?
17 में भी नोटिस का रिक्वायरमेंट हो जाएगा. ये दो ही तरफ से अपियर हो रहा है. इसमें
I am the procedure, so I
अभी जब आएगा तब देखेंगे.
only request by
Item 10 second to 49
ये कॉपी प्रोवाइड
caveat दिए हैं.
तुरंत
caveat दिए तो बहुत जो है
अभी तुरंत दे देना.
I don't have any right, but still after admission.
आप तो एडमिट हो गया ना, आप देख.
Item 10 second to 49 of 1021.
Lord, appellant before your lordship is defendant before the court. Plaintiff instituted a suit was dismissed. Then, my lord, plaintiff preferred an appeal, and during the pendency of the, my lord, the appeal, your lordship, several documents, your lordship, were exhibited, and my lord, even the plaint, your lordship, was also amended during the judgment itself. It will show, and my lord, judgment has been reversed. Relying upon those judgments, I am relying on a Supreme Court judgment that, my lord, the course followed by, my lord, the appellate court is, my lord, for first.
You were given due opportunity to respond.
No rebuttal evidence was given. That what is the judgment? Your lordship may kindly see the second part.
So, substantial question of law
Yes.
number A should be sufficient.
My one more substantial is question of law. Your lordship is also
You
required
see,
to-
if A is satisfied, what is the remedy? We have to remand it.
Yes, but my lord, B also is required because, my lord, the learned trial court has, my lord, constituted Exhibit 3. Your lordship.
Exhibit
And, my
3
lord,
is what?
Exhibit 3 is an order passed by the additional collector, which is in the contravention of the sale deed, on the basis of which, my lord, these plaintiffs are claiming rights. And, my lord, the learned trial court discarded it. Appellate court, your lordship, has not properly constituted, rather, my lord, without meeting the reasonings of the trial court, has, my lord, allowed this. Whole case, your lordship, is based on exhibit 3. That I have framed
Or
as
the-
C.
For the learned counsel appearing on behalf of the appellant, the learned counsel for the appellant has submitted that the first appellate court has proceeded in a manner which is contrary to the provisions of Order 41 Rule 23A to Rule 25 of CPC. He has submitted that numerous documents were placed on record as additional evidence, but no opportunity of rebuttal was granted to the defendant. The learned counsel submits that the suit was dismissed. The learned first appellate court has reversed the judgment, and the defendant is the appellant before this court. The learned counsel has also submitted that the first appellate court has failed to construe and examine the Exhibit 3 in its correct perspectives and has not met with the reasons which has been assigned by the learned trial court while dealing with Exhibit 3. He submits that on the point of perversity with regard to construction of Exhibit 3 by the first appellate court, another substantial question of law arises. He has also submitted that in case the first substantial question of law is answered in favor of the appellant, then the matter is to be remanded to the first appellate court for the needful. And in such circumstances, the second substantial question of law need not be answered. Correct? This second appeal is admitted for final hearing on the following two substantial questions of law. A and C, issue notice to the respondents through ordinary process as well as through speed post, for which requisites be filed by the appellant within a period of 2 weeks from today, that the records be called for from the concerned court. एक ऊपर लिखिएगा, the learned counsel has relied upon the judgment passed by the Honorable Supreme Court report dated 2018 SARs within bracket civil 1036 within bracket the Corporation of Madras and M. Partha Sarthi.
Lord, in this particular case, the Honorable Apex Court has said what manner the appellate court should decide here. So, may kindly just the last part. The first appellate court has two options. First, it could have set aside the entire judgment and decree of the trial court. Did my lord find it?
Para
By
number?
taking the reports
Para
to
number?
the para number 14 to 24.
Yes. Para 14 to 24.
Para 14, in considered opinion, appellate court committed two jurisdictional errors in the along here. First, it took consideration the additional piece of evidence while deciding the appeal on merits without affording any opportunity to the appellant to file any rebuttal evidence to the counter the additional evidence produced by the respondent. This was prejudice to the appellant hearing because they suffered an adverse order from the appellate court on the basis of the additional evidence produced by the respondent for the first time in the appeal against
That's
them.
right.
See land acquisition
I have just recorded it. Para 14 to 20. 14 to 20. इसका एक judgment का ना copy करके
Apart from
बता
that,
देना.
there is one more illegality has been committed by the appellate court. That the appellants have, the appellant there, plaintiff have filed amendment petition, and I have filed rejoinder to that. That has been also allowed during the appeal itself. Your Lordship may kindly see the
No,
judgment.
amendment can be allowed at any stage.
But at least, if
Additional written statement was not filed.
No, what I am saying, suppose somebody is trying to amend the plaintiff, and
Yes.
the appellate is saying,
Yes.
suppose there is wanted to this effect has been filed.
Yes.
But it should be the learned court should pass order on it.
Yes.
So that
So by the appellate order only.
Yes, yes, sir.
Where is that?
Yes. Lordship may kindly see page number. It is page 30.
39.
Page 29, my lord, page 30, 30 of the
Yes, page 30.
30. The Lordship may kindly see the point has been framed. Whether the proposed amendments of the plaintiff is permissible.
Just a minute.
How it is possible?
एक चीज और लिखी. The learned counsel for the appellant has also submitted that the first appellate court allowed amendment of the plaint.
Yes.
Amendment of the plaint while passing the final judgment. He submits that the amendment to the plaint can be allowed by a distinct order.
Yes.
So that an opportunity of filing additional written statement is provided.
Or
And
it can be assessed before a superior court of law.
just a moment. or it can be assailed before the superior court of law, and evidences are also required to be adduced in connection with the amended plaint. एक चीज और लिखिए substantial question of law में, whether the learned first appellate court was justified in amending the plaint while passing the final judgment.
May kindly see Malad page 47. Malad, just second line I would like to read. Plaintiff appellants are permitted to amend their plaint as ordered in para 60 and 61.
That's right. ठीक है ना, इसको भी एक substantial question of law बनाना। सर क्या चल रहा है? आप लोग पढ़ाते नहीं किसी को ढंग से?
That class तो हमने लिया था जुडिशियल एकेडमी में।
जुडिशियल एकेडमी में क्लास से नहीं होगा, वकीलों का क्लास शुरू करिए।
तो जज साहब ऑर्डर।
हाँ? तो क्या हुआ? वकील नहीं असिस्ट करेंगे जज साहब को, तो जज साहब कौन सा ऑर्डर कर देंगे? बताइए।
सब गलती वकील।
सब गलती?
वकील।
ऐसा तो नहीं। I just चलिए इसको जल्दी ही डिसाइड करेंगे, ठीक है ना? इसको क्या बोलें, ऑर्डिनरी प्रोसेस स्पीड पोस्ट 10 दी देंगे, अब डेट एक तो फिक्स कर देते हैं। पोस्ट ऑन 19 September, awaiting service to court, office to track speed posting.
Item 11, second bill 52 of 921.
Records call for करने का ऑर्डर करेंगे, है ना? Yes.
There's the plaintiff's second appeal against the concurrent finding of facts in law. So far as the plaintiff is concerned, his case was that he was there on the suit land since 1973, and the cause of action, immediate cause of action was that he got a notice which was in relation to an execution case arising out of a title said suit which was instituted against one Sri H.M. Patel, not this appellant. Thereafter, the appellant came to know.
What was the execution case number?
The execution case.
Case number?
Execution case number is 12 of 2002.
He got notice when?
He got the notice 12/4/2006.
You were in possession of the suit property?
Since 73, that is our pleading in the plaint.
What did you do?
And then
What did you do?
he was running a shop from there.
No. What did you do to this notice?
Thereafter,
You filed a separate suit,
filed a separate suit.
not one separate.
And,
Execution का notice मिलेगा, आपको उसी में objection file करना है. That is to be.
Order 21 Rule 101 has been discussed by the.
Yes,
direct
I've
court,
seen that.
That there is a bar under.
Otherwise क्या होगा? Parallel decree हो जाएगा ना?
Because 103 says that it will be a decree in terms of.
Mr. Banerjee कुछ है नहीं आपके केस में.
एक खाली adverse position का issue जो है.
नहीं.
First court तो appellate
नहीं,
court
नहीं.
has done some repairing, but appellate court has not considered. First court did not consider the subsequent.
जबरदस्ती वाला काम मत करिए ना. The court has said simpliciter primarily that you cannot, that second suit is not
Yes,
maintained.
on that the issue of law I cannot dispute so much. Only I was on adverse position, the finding of the learned appellate court.
कुछ
and
नहीं,
adverse-
when it is not maintainable तो क्या ही बचा उसमें?
On that there is an adjudication on the issue of adverse position by the.
नहीं उस पर नहीं. We will simply say that it was not maintained. Fresh suit was not maintained.
The findings on adverse position of the learned appellate court are there at page 19 onwards, 18, 19 onwards.
starting. Basically, paragraph 18, page 50. On that, if Lordship kindly comes to page 16, only one issue I will raise subject to Lordship's kind consideration. Maintainability I cannot dispute so far as issue was. Running page 16, it has been considered against me. One of the primary reason is that state was not implemented as party when the suit was filed. The state was implemented by way of an application under Order 1 Rule 10(2) in 2016. That is during pendency.
So we are not bothered about it. आप state को party बना के कर लीजिए, इसमें क्या है?
नहीं वो पार्टी हो गया, बट हम बोल रहे हैं अपीलेट कोर्ट इसलिए मेरा एडवर्स पोजीशन को कंसीडर नहीं किया।
स्टेट नहीं ना है पार्टी, अब स्टेट को पार्टी बना के आप एडवर्स पोजीशन क्लेम कर लीजिए।
हाँ पार्टी बना दिए, तो पार्टी बना दिए, उसके बाद फिर वहाँ शूट में ही बना। बट कोर्ट इज सेइंग कि जब आप प्लेंट फाइल किए थे तब तो थे नहीं। कोर्ट हैज अर्ड इन नॉट
अपीलेट स्टेज में कर दिया।
नहीं, ओरिजिनल सूट वाज पेंडिंग, सूट वाज डिसाइडेड,
नोटिस वाज इशूड,
सूट वाज yes,
notice was issued. They did not file any written statement.
No written statement was there.
I don't know. You just tell me the state was a party.
इस यही पर है पेंडिंग लिखा हुआ 2016 में हुआ। पेज 16 एक बार देखेंगे। पेज 16 में नीचे से जहाँ 73 लिखा हुआ 20 से बॉटम पूरा नहीं पढ़ेंगे। फरवरी 73 लिखा हुआ, रनिंग पेज 16 है, अपीलेट जाता है। नीचे से
रनिंग पेज
16 है, ऊपर लिखा हुआ।
You see, how could you claim adverse position against state when the suit was decided in favor of the plaintiff in the which related to the execution case?
That was one of the prayer relief sought for in the suit. That decree is not binding upon me. That is, since I was not a party.
ना, तो वो तो आपको उसी में करना।
Because state is the paramount owner.
No, they are not. The state is not a party over there. In the previous suit, state is the party.
In the previous suit, I was not a party to the suit.
That's right. Execution case में if you have an objection from execution case, तो अलग-अलग तरह का relief आप जोड़ दीजिए।
इसमें एक ही वो हम कर सकते थे substantial question of law proposed जो इस point पर कि already जब party हो गया, then what is the consideration that आप initial stage में नहीं थे, बाद में बने।
भाई state को तो state के favor में तो declaration ही नहीं हुआ था suit property का, because it was in declaration of in favor of one पटेल।
हाँ वो पटेल। लेकिन इस सूट में जो मेरा जो एडवर्स पोजीशन वाला नहीं कंसीडर किया गया, ये बोलते हुए कि आप स्टेट का होस्टाइल पोजीशन बोल रहे हैं, होस्टाइल पोजीशन अगेंस्ट स्टेट, और स्टेट को ही आप पार्टी प्लेंट में नहीं बनाए थे, बट विदाउट माने दिस अल्टीमेटली स्टेट वाज इंप्लीटेड पार्टी ड्यूरिंग पेंडेंसी ऑफ द सूट। So it amounts to, it goes back to the date of filing of the suit once order 1 rule 10 has been allowed. That is the only thing which we can submit.
No, you just tell us, even if the appellate court has said something that he was party or not party, but the fact remains that the suit itself was not maintainable.
That is true. That we
then if it is not maintainable, the matter ends. What is there?
Then in that light, it may be so that
you will not observe anything. You will just simply say that the suit was held to be not maintainable. देखिए second appeal number 52 of 2021. Heard the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant submits that he was in possession of the suit property since 1973, and he received a notice in execution case number 12 of 2002. With respect to the same property, the execution case was filed at the instance of one?
At the instance of Tata Iron Steel Company Limited, the plaintiff in the previous suit.
At the instance of Tata Iron and Steel Company Limited, the plaintiff in the previous suit. And Patel con?
They say that we have settled it with Patel in 1937. That is prior to lease.
Wherein,
but he was never found to be in possession.
And the suit was decreed in favor of the Tata Iron and Steel Company on the ground that the property was already settled in favor of one
H.M. Patel.
H.N. Patel.
The defendant in the said previous suit.
The defendant in the said previous suit. And an order of eviction was passed against the said defendant.
Yes.
Correct?
Yes.
Fact में तो error नहीं है.
नहीं वो है pleading नहीं.
The learned counsel submits that instead of filing objection in the suit, in the execution proceeding, the appellant had filed a separate suit
year 2006.
Being original title suit number 54 of 2006. Claiming adverse possession against the state. And also challenging that Mr. H.P. Patel was never in possession of the same suit.
He was a fictitious person, and so the decree was not.
And he was a fictitious person. The learned counsel has submitted that the suit was maintainable and therefore the same could not have been rejected as not maintainable by referring to Order 21 Rule 100
101.
101
101
of
says about
CPC. And therefore a substantial question of law arises for consideration in this case. After hearing the learned counsel for the appellant and going through the impugned judgment, this court finds that it is not in dispute that title suit number 194 of 1994 was decreed. On 29/7/2000. And an order of eviction was passed, in which the appellant was served notice through execution case number at the stage of execution of the decree through execution case number 12 of 2002. This court finds that both the learned courts have held that a fresh suit was barred under law. The learned कहाँ है finding trial court का?
Yes, so the first court's finding, so the very last that is running page 45.
The learned trial court held that the suit was not maintainable and decided the same in paragraph 14 as follows. Correct? The learned first appellate court has given concurrent finding on this point. In paragraph 21, as follows. This court finds that both the learned courts have given concurrent finding with regard to maintainability of a separate suit by a well-reasoned order, and finds that by well-reasoned judgments, and finds that no substantial question of law arises therefrom. Accordingly, this appeal is hereby dismissed.
Item 12, second appeal 69 of 2021.
May it please your worship. The plaintiff is the appellate before your lordship. Judgment of concurrence.
Yes.
Case according to the plaintiff was Miller that in 1944-45 he came into possession of the property by way of a hukumnama, and subsequently further lands were added by a sale deed, but it could not be registered as the vendor was ill and he could not go to the registration office, and subsequently he died. So my case is, my lord, that I am in possession since 1944, and thereafter the day when the owner of the property gave it to me by a document and possession was given in 1951.
Who gave you possession?
The owner of the property.
No, he died, no?
Vendor.
The vendor died.
He died.
Who gave you possession?
Prior to his death.
Okay.
Yes.
When were you put in possession?
1951.
And when did he die?
He died in 1956 he died.
And when was its sale deed executed?
It was executed.
What is the date?
At the amount was
Amount
300
नहीं, date बताइए.
300
9/6/1951.
is that on receiving Hukumnama of 17 through Hukumnama of 2nd March 2001.
This is an unregistered document. इसका क्या relevance है?
नहीं ठीक है. Possession हमारा adverse है that the trial court framed the issue, but appellate court failed to frame such issue. The only one ground of determination was framed with regard to title. Well, if I am permitted to place paragraph 8 minor, and if I am permitted para 8 minor, but apart from the this, after going through the plain WS judgment of the learned court below, I find that the question of determination before this court is para 8, whether the appellant plaintiff acquired right title interest over the suit property or not. Now my case is that I am in adverse position since last about 50-60 years. And we'll have one thing more if I
Who sold the property?
My lord?
Who sold the property?
Tulsi Gop executed sale deed Milord in 19...
With respect to the same property, which was covered by Hukumnama.
No. Another property. By Hukumnama, I got 8 decimal of land. By this document, sale deed, although could not be registered, 32 decimal of land.
इसका कोई relevance नहीं है ना सर?
तो adverse position में हो गया ना? ट्रायल कोर्ट ने उसको फ्रेम किया, एक भी विटनेस को कंसीडर नहीं किया. Appellate court also did the same mistake, if I am permitted to say in law, that it did not consider even one witness, although I had given as much as 7 witnesses and a number of exhibits and 4 exhibits. The court did not consider even one.
Can you take a contradictory plea? One is on the basis of sale deed and other on the basis of adverse possession simultaneously.
Yes, let's can you yes.
ऐसा ही finding है.
Because finding उनका है, that finding is not subject to challenge, and that finding, in my humble submission, is not permissible in law. Because a man who has got a sale deed, though not registered, possession was given by that document. So there is a proof that possession was given at least. And I am there since 1951 till 2002, my lord, when the suit was 2002, when the suit was filed. And my lord will find from, I can read the entire judgment, not one PW out of the 7 PWs has been discussed.
आप हमको पैरा नंबर 12 पढ़िए.
जरूर.
इसमें perversity दिखाइए. पैरा नंबर 12.
From perusal of the plaintiff, it transpires that the plaintiff claims the suit property on the basis of sale deed as well as on the basis of adverse possession. It is settled principle of law that plaintiff cannot sail on 2 boats. Now, look, the sale deed, I cannot.
सर बाद में पूरा पढ़िए.
Oh, apology. Simultaneously, but even if the plea of adverse possession is taken into consideration, the plaintiff has to prove that possession of the plaintiff appellant over the suit land alleged to have acquired by way of purchase
and adverse possession never remained uninterrupted and peaceful. First of all, the wife of Tulsi Go sold in favor of Dharam Go, for which a panchayati was convened in between Dharam Go and defendant thereafter. Dharam Go released the suit land in favor of defendant and accepted the possession of the defendant, and has also been accepted that Tulsi Go, my vendor, the Rayat donated the same in favor of the defendant. No document has been placed.
Sir, आगे पढ़िए.
And accepted the possession of the defendant, and has also accepted that Tulsi Ko, the Rayat, donated the same in favor of the defendant. There is an application on behalf of Rijo Mato, father of the plaintiff, to the effect that he made a request to defendant Exhibit A by 3 for obtaining water from the well and pathway, as there is no facility of water and way. Then the father of the plaintiff also made a request to Mahant Ram Lakhan Das to maintain his wife. Exhibit A. Exhibit A by 5 shows that Rijo Mato was given permission to use the way and well by the Mahant Defendant Trust. A perusal of document discussed above, the plaintiff appellant has not objected as at any moment of time, which shows that Rijo Mato, alias Rijo Sundi, submitted the possession of the defendant.
Admitted the possession.
Pardon?
Admitted the possession.
Admitted the possession of the defendant trust. Thus, the plaintiff appellant failed to prove that he remained in uninterrupted possession in the suit land with the knowledge of all. Thus, title cannot be confirmed in favor of plaintiff appellant on the basis of adverse possession. Now, my lord will kindly allow me to place. My exhibits have not been considered, even one.
What was your exhibit which was required to be considered? Which exhibit was required to be considered? Which would have given a different judgment altogether?
Even the
exhibit number बताइए. कौन सा exhibit
आपका? In the sale deed, the possession is being number one.
Sale deed
Let me answer the query of this honorable court.
आप बताइए, आप बोल रहे हैं आपका एग्जिबिट नहीं कंसीडर किया, आपका कौन सा एग्जिबिट नहीं कंसीडर?
मेरा पहली बात यही पर मेरा जमीन का टाइटल, मेरे जमीन का पोजीशन मेरी वाइफ कैसे किसी को दे सकती है? एंड हाउ वुड आई से कि मेरी वाइफ का देख रेख आप कीजिए? ऐसा कोई होगा? जीवन में पहला बार हम पढ़े कि कोई आदमी कहे कि मेरी वाइफ का आप रक्षा कीजिए।
आपका कौन सा एग्जिबिट कंसीडर नहीं किया, आप ये बताइए।
I may please.
Which exhibit has not been considered?
Now, my exhibits are at internal page 9 of the, but from the trial court. Appellate court has not taken into consideration even one.
आप बताइए ना, कौन सा एग्जिबिट से आपका पूरा तख्ता पलट हो सकता है, बताइए। हर appellate court in a judgment of concurrence is not required to discuss everything. Therefore, you have to show me that document कि ये particular चीज को consider करने से the judgment would have, it is a material exhibit.
Yes.
All exhibits are not material exhibits.
Well,
which material exhibit do you say?
Nominal. The document Hukumnama, which gives me the, which is the proof of possession since 1944.
हुकुमनामा कौन इशू किया था?
My lord, it was issued by the vendor.
रैयत पावर है उसको करने?
नहीं है, नहीं।
तो फिर हुकुमनामा वैसे ही खत्म है।
Adverse possession.
Adverse possession ऐसे नहीं होता है सर। This is not the way in which adverse possession is declared.
My lord will kindly consider.
हुकुमनामा is absolutely null and void. उसका कोई मतलब नहीं।
I am not making any submission with regard to the
agreement क्या है? What is this agreement about?
With regard to the legality of the hukumnama, I don't make any submission, but I say that shows that the possession was given to me.
हुकुमनामा के बेसिस पे आप पोजीशन नहीं क्लेम कर सकते, आप इतना सीनियर हैं, ऐसा बहस मत करिए।
मतलब मेरा पोजीशन तो है ना,
कैसे?
मेरा गवाही है ना,
गवाही से
गवाही
क्या
है।
होगा?
I have given evidences. फिर अधिवक्ता आयोग का फील्ड बुक है।
अधिवक्ता साहब आज आके क्या कर दिए?
Pleader commissioner was appointed.
भाई उस वक्त आप पोजीशन में थे, इससे क्या लेना देना है? आप किस समय से पोजीशन में, आप ही बताइए। इसमें आप डेट दिए हैं किस दिन आपका एडवर्स पोजीशन हुआ? On which date you were in adverse possession?
After 12 years.
From which date?
From the date it was given to me in
आप बताइए ना डेट बताइए। You are claiming since 1944? दो डेट आपका आ गया है। 1944 का हुक्मनामा।
पूरा जमीन एक बार में नहीं खरीदा है। पहला जमीन में 8 डेसिमल, दूसरे में is a larger land 32 डेसिमल। So my lord, exhibit 1 is अधिवक्ता का फील्ड बुक, नंबर 2 इज अधिवक्ता द्वारा तैयार मानचित्र, उसमें तो बना के कहा कि ये मेरे पोजीशन में है। देन हुक्मनामा exhibit 3, then agreement exhibit 4. Now my lord, my consideration in the trial court starts from para 5. वादी साक्ष्य संख्या 1, 2, 3, 4, 5, 6. 6 is वादी. He is the PW6 घनश्याम मंडल।
सेकंड आप करते हैं।
मतलब इसको if my lord pleases, इसको अगर मंडे को रख दिया जाता।
प्रेयर रिजेक्शन सेकंड हाफ में।
अच्छा।